All right, the 14B District Court is now in session. My name is Elaine Washington, and I'm the judge that will be presiding over this session. The court will call the case of Lakeview versus Michael White, case number 26C2307.
Good morning, Your Honor. Rachel Dornbush.
Okay, this is Brecken's fault. I have no idea what we're getting into. None.
Pallets Law, P78301 on behalf of the plaintiff.
Thank you.
I should restate that case number 26C0307.
Do you want me to replace my appearance on, Your Honor?
No, you're fine. Mr. White, please unmute, state your name.
Michael White,
Thank you.
represent Phelps.
Thank you. We're here for non-jury trial today.
We are indeed, Your Honor. And just as an initial matter, at the last hearing on the 25th, when Your Honor set this over, the court had ordered the parties to exchange documents by April 6th. My client hand-delivered to the property copies of the documents that we intended to utilize as exhibits for court today. They're the same documents that I emailed to the Civil Division yesterday. I haven't received anything from Mr. White.
Well, you bring up two interesting points. One is, maybe I wasn't clear, but when you filed with the defendant, I was hoping we would file with the court too. But I understand that.
My apologies, Your Honor.
And Mr. White, you don't have any exhibits that would be admitted today because you didn't exchange any with the plaintiff, correct?
I have brought witnesses with me here to testify on my behalf.
Witnesses are different, but you don't have any documentary
He's got witnesses and it's not right, Judge.
exhibits, correct?
No, Your Honor, I didn't receive their documents because I'm still locked out of my mailbox, and the care staff that I had, they weren't able to drive up there due to strict company policy that they did not want to violate to take me up to get my mail.
They were not mailed, Your Honor. They were hand-delivered to the property.
Hold on. Excuse me for a second, Your Honor. Did you get anything that was on my door?
No. I didn't.
And I think Willow did, and Isaiah was here last night, and he didn't say anything.
They were hand delivered on April 6th, sir.
Forgive me, Your Honor. I have several medical personnel coming in and out, and the ones that I have here now said that they didn't have anything in the door.
When you say they were hand delivered to person, put on the door, what, Ms. Longbush?
Your Honor, my client representatives are in the waiting room. They'll be able to verify exactly how they were placed at the property.
All right, please let them in. Well, there's enough opportunity. You may ask your clients how those were delivered.
Thank you. Dana, Ms. Green, the documents that were delivered to Mr. White on Monday, who delivered them and how were they placed at the property?
Austin.
We mute it, sir.
What did she say?
Me and Brian delivered them by hand.
Where did you take them? Did you tack them to the door? Did you hand them to an individual?
No, we walked up the stairs. Well, yeah, we handed them to his nurse and maid, or the person that was there with him. And
Can you identify that person's appearance? What did they look like? Was it a male? Was it a female?
it was a female nurse.
One moment, please. Sir, please raise your right hand and be sworn. You swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
What is your name? Please state and spell it for the record.
Austin Waginka.
Spell it. Please spell it for the record.
Oh, Austin Tyler Waginka.
Spell S-P-E-L-L, please spell it.
WGIENKA.
First name Austin, spelled A-U-S-T-I-N.
Yes.
Thank you. All right, now you're saying who delivered it? Did you or someone else?
Me and my fellow maintenance man, my other coworker,
So two of you were together. Who had the document in their hands?
I did.
And you took them and you delivered it to who?
The Mr. Michael White. We
You
dropped
gave
it
them to
off.
Mr. Michael White.
Yeah, him and his nursing assistant that was behind him. He shortly after he received him, he gave him to her. And
So you saw Mr. White that day?
yes.
And you gave them directly to him and he gave them to someone else?
Yeah, they were standing there conversing with us for about 5-10 minutes.
Okay. All
You
right, thank
I
you,
can
sir. Thank
stand
you,
out there
sir.
for like 10 minutes to talk to anybody? No.
All right, thank you. Mr., how do you pronounce your name? Sir, how do you pronounce your name?
Waginga?
Thank you, Mr. Wiginga.
Thank you.
I mean, I wasn't gonna ask, but I am curious.
Mr. White, you just heard the testimony. He said he handed them to you directly.
I won't rule that out, Your Honor, because I have a traumatic brain injury that's been well documented that causes memory loss. So some bits and parts of my memory, if I laid them down at all, because I'm on crutches, and couldn't carry them myself, if my care staff laid them down, either forgot about it. Can they tell me what the documents that they dropped off?
I'm happy to go through those, Your Honor, if the court pleases.
I don't. They were exhibits. Sir, you need to look for the exhibits that were dropped off to you.
Any idea what they, like the front page of them would have been?
Your Honor, it would have included the lease agreement, the ledger, lease renewal offer letters from that were issued in December of 24, as well as December of 2025, and then letters from both April of 2025 and April of 2026 confirming his month-to-month status, and then 4 photos that my client took of the driveway.
Were they in an envelope or what, Mr. Wiginga?
You're
You're
muted,
muted.
Mr. Waginka.
Yeah, this is the,
They were freshly printed off and stapled together in a Sun community folder.
other than the lease, what's supposed to be in here? Because I found a copy with the lease where they were telling me to
Right.
sign it.
Mr. White, she just gave you a whole list of what's supposed to be in there. I'm not going through that list again.
All this is, Your Honor, is a copy of the lease and wanting me to sign it and the places, the documents on back, but I cannot find anything in this packet other than the lease itself.
Your Honor, the document that Mr. White is referring to is the document that my client hand delivered on or around, I think it was March 18th, when they did a full assessment of the driveway at that time. And it was the lease renewal with the term of April 1st, I believe, 2026 through March 31st, 2027. And it was marked so that way Mr. White knew where to sign if in fact he wanted to renew his lease rather than being a month-to-month tenant. According to my communications with Mr. White yesterday, he was still in the process of potentially executing this document and having his care staff return it to be on a new lease term, even though we're now 10 days into that period. My client would still accept it at this point.
That's not the document, sir. It's a different packet of documents.
Yes, Your Honor. And while you all been talking, I've been frantically searching the only place that it possibly could be where paperwork gets stacked and it's left there. And can you look through there and see if there's anything? I can't hold that. Anything that has like Lakeview Lease, anything on there?
We're gonna get started.
Go ahead, Your Honor. I apologize.
Ms. Dornbush, so the way this works, not Ms. Dornbush, Mr. White, the way this works is you're gonna do what's called an opening statement if you so choose, and then, each of you will call your witnesses. So she will start with her case first, and then once she rests, it will be your time to present your case. When she calls her witnesses, after she's questioned them, you may then question them yourself. And if your questions aren't phrased properly, I will rephrase those questions and ask them myself. Okay?
Thank you, Your Honor, and please keep in mind, I'm not an attorney. I'm very, very new to this court proceedings, and I'll try my hardest to proceed
Oh, we know.
without delaying you any further.
Nobody's confused about that.
Thank you. All right, Ms. Dornbush, do you have an opening statement you'd like to make today?
Very briefly, Your Honor. This is an action for non-payment of rent, Your Honor. Plaintiff is seeking a judgment of possession requiring defendant Mr. White to carry the rental arrears on his ledger. The court will find after testimony that the current balance due and the amount that plaintiff is seeking a judgment for totals $2,995.30. Based on the prior proceedings in this matter, it is my understanding that Mr. White may be disputing some of that balance or all of that balance. Nonetheless, Your Honor, I believe the evidence is going to show that there is no legal defense in this matter and plaintiff is entitled to a judgment.
Thank you. Sir, would you like to make an opening statement at this time?
Yes, I would, Your Honor. This issue here, never about money. It's about my safety and the safety of the care staff that's coming in and out of this house on a daily basis. I've been trying to get them for 15 months and counting to repair the concrete of my driveway. And every time it keeps getting blown off and pushed back. And I came to the sudden revelation that the only way I'm going to get them to repair the driveway, which I'm handicapped and endangers me on crutches and endangers the safety of my care staff, would be to withhold rent. So I showed the court and proved that I had a cashier's check in amount to $2,000 because at that time in the first court proceedings, I only owed just under $1,900, which they could have had months ago if they just simply repaired the driveway that I kept getting promised would be repaired over and over again. And so, and it's the same stance. The only way that driveway is going to get fixed by me withholding my rent. And I'm not a deadbeat. I got thousands of dollars in the bank. It's just that I've been so stressed out and so worried that I was going to slip and fall with my crutches and get hurt. It caused me to be more stressed, which is an issue because I survived a few heart attacks. And within the last one's about 16, 17 months ago. And so here we are today to force them into fixing it. And then the other point was I signed a lease that went from basically from month to month to 12 months when I realized that my medical conditions deteriorated to the point where I wasn't going to be able to move physically at that time. So I figured I better sign a yearly lease to save me, $40, $50 a month. And then at a later time, I found out that they lost that lease. And from the time they told me they lost that lease, it's like I felt that it wasn't fair for me to pay $40, $50 extra per month for a month-to-month lease when I signed and delivered to their office a yearly lease. And so, and we went back and forth for months and months over that when they kept telling me they haven't found it yet, they're looking for it. And then the last communication I have, they said they couldn't find it. They couldn't find it. When I have people here to prove that I did sign the yearly lease to go off of the month to month, and I don't think it's fair for me to be charged, $40, $50 extra per month when I signed a lease and delivered to them. And so we'll let Your Honor resolve this, and whatever money that they say that I owe, I'll pay immediately. But did I hear that right? If they're saying it's $2,900, it was under $2,100 the last time we had the Zoom court. I don't understand how it could jump up $800 more.
I was in March and the new month has happened.
Okay, I brought him a check for that rent, $800, which should have covered that month's rent.
What day did you bring that money in, Mr. White?
I would have to be on this phone to access my bank, and they'll tell me when that check was cashed.
Are you talking about for March or for April, sir? We have your payment for March. On March 5th, there's a payment of $800. Are you saying you made a payment this month as well?
I believe so, but I would have to check to make sure it was brought up there. Because one of my issues is I have so many different people coming in and out. It's hard keeping track over who did what. If I still owed rent for this month, I will pay it immediately.
All right, thank you. All right, Ms. Dornbush, you may call your first witness.
Thank you. Your Honor, plaintiff calls Miss Dana Green.
Hello,
Hello, Ms. Green, please raise your right hand and please swear. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
yes,
Thank you. You may begin, Ms. Dornbush.
Thank you. Your Honor, Miss Green, please state your name for the record, spell your first and last.
Dana Green. My first name's Dana, Dayna, and my last name's Green, Green.
And are you the manager for Lakeview?
I am.
Are you familiar with the books and records of the residents of the community?
Yes, I am.
Are you familiar with the tenancy of the defendant Michael White in the community?
Yes, I am.
This defendant leased the property commonly known as.
Correct.
Ms. Green, how long have you been the community manager for Lakeview?
I was officially the manager as of September of 2025. I was a covering manager since June 19th of 2025.
And how long have you been in property management?
Roughly 20 years.
And how long have you been a community manager for Sun Communities?
It will be 3 years this September.
Thank you. In your capacity as community manager, what are some of your duties?
Daily tasks, overseeing all the staff, budgets, resident relations, payments, posting payments, court, issuing 7 days, being in court, basically overseeing the entire property and the needs of the property and residents.
Thank you. Your Honor, I'm going to attempt to share my screen now. I want to just make sure that I'm sharing the right screen. So bear with me a moment while I make sure I'm doing this correctly.
All right, thank you.
Okay. Is the screen shared with the folder and the documents?
No, it's still you.
Okay. Oh, here we go. I had hit share screen. There we go. Is the court able to see? And Ms. Green, are you able to see the screen with the documents?
Probably
Yes.
need, we can see it, but it probably needs to be a little bigger once you get the document that you're looking for up.
Absolutely, Your Honor. Okay. Your Honor, I would like to have this document marked as Plaintiff's Exhibit 1.
All
And I
right,
can mark it with the text box myself.
I think we need to give him a chance to read it since he can't find his documents.
Did you
Understood.
see it anywhere, Rebecca?
Reference for Mr. White to see and understand what the document is, or if the court would like me to describe it as I'm going through it for Mr. White's benefit, I'm happy to do that as well.
Please describe it for his benefit and mine.
Thank you, Your Honor. This is a document. It indicates Sun Communities, Inc. on the top. It indicates Lakeview and the address of the management office in the upper left-hand corner. It is a document with the date of April 7th, 2021. The defendant's name and address are listed, and it indicates that effective for April 7th, 2021, that the monthly rental rate for the property is $576. Letter that was sent to Mr. White, as I indicated, dated April 7th. And the subsequent documents in this package, Your Honor, are the applicable lease agreement from that time frame. This particular document, Your Honor, and Mr. White, it is a 20-page document which contains an original lease agreement from the date being April 7th of 2021, a lease term from April 1st, 2021, and going through March 31st, 2022. This is, and I'm going to minimize this, maybe we can see each page. And Your Honor, if Mr. White or the court desires me to zoom in on anything, I'm happy to do so, but to go by page, I'm zooming out slightly. Page 1 is the front page of the lease. Page 2, 3, 4, and 5 of this document as a whole contains the lease, and it contains the signature, what appears to be the signature of the defendant and what appears to be the signature of the former manager whose name was Brittany Parker. This appears to be signed by both parties on April 7th, 2021. There is a document after this, which is an acknowledgement of the community rules and regulations. It contains the signature, which appears to be that of Mr. White, also from April 7th, 2021. And it also includes, starting on page 7 of the PDF, the community rules for Lakeview. This document is unnumbered, but it contains several pages which set forth the rules and regulations of the community. The next document is an emergency and community interest phone numbers, which list a number of phone numbers for the community, emergencies, sheriff's department, state police, fire department, ambulance services, and other relevant phone numbers, Your Honor, that may pertain to residency in the community, such as DTE, AT&T, Animal Control Post Office, Comcast, Mistig. It also indicates the community hours. This document, Your Honor, also contains from March of 2020, the letter and original lease from 2020, Your Honor, and it set forth the terms of the tenancy at that time. This was for a lease term of April 1st, 2020 through March 31st, 2021. And it also purports to bear the signature at the end of the then community manager. Again, her name was Brittany Parker, and what appears to be the signature of Mr. White. Upon information of belief, Your Honor, I think these are the last leases that may have been signed by Mr. White, but I would have to verify that with Ms. Green through testimony.
Thank you. Any objections to admission of Exhibit 1? Mr. White?
No, Your Honor.
All right, Exhibit 1 is admitted.
Thank you, Your Honor. I'm going to start with the lease from 2020, Your Honor, as I believe that this is one of the first leases that Mr. White had in the community. And Ms. Green, I'm going to refer you to what is page 14 in the packet that was provided. And do you recognize this document?
I do.
And what is this document?
It would be the front page of the lease for that time period.
And in looking at this document, do you see a date of the relevant period?
I do. It was effective February 1st of 2021.
I'm sorry, looking at page 14, Ms. Green, I think you may be looking at page 1 of the document. This document actually contains 2 lease agreements. And are you able to see it on the screen, the document that I'm referring to?
Yes.
Okay, and the date that's referenced up here?
Oh, I'm sorry. March 3rd, 2020.
Thank you.
Would have been when it was sent. I'm sorry.
Thank you. And does it indicate an effective date here?
No. In the top left corner, no, but down here it does.
And what was the effective date of this document?
February 1st, 2020.
Thank you. Moving on to page 2 under this contract.
12 months.
And when does it run from?
It runs.
If you look under the paragraph identified as term, it indicates a 12-month period. Do you see the date of
Oh.
commencement?
I'm sorry. Yeah. April 1st, 2020 through through March 31st of 2021.
And is that a standard lease term for Sun Properties and Lakeview in particular?
It's a standard. We only offer 12-month leases.
Thank you. And does this lease agreement indicate the rental rate that was applicable at the time?
Yes, it does.
And what was that rental rate?
$554.
And does this lease agreement indicate when rent is due?
Yes.
Do you know when the rent is due?
Yes, it's due the 1st of every month.
And do you know if there are any applicable late fees if a resident fails to pay as due under the lease?
Yes, as of the 6th of the month, they would receive a $55 late fee.
And is that referenced here in the lease agreement?
Yes.
Is that under paragraph identified as late charges and NSF charges?
Yes, it is.
And are there any other late fees that are charged?
Yes, the second late fee of $30 will apply on the 20th of the month.
Thank you. Under the lease agreement, excuse me, is there any requirement in here for a resident to, how a resident would report concerns to the community?
Yes.
And what is the standard expectation under the lease agreement and or the rules and regulations for a tenant to do so?
To make the office aware, they would need to either call it into the office or come into the office and let us know.
And are you aware of any concerns raised by Mr. White under his tenancy?
Yes.
Specifically raised this year in 2026 regarding his tenancy?
His driveway.
Thank you. I'm going to draw your attention to the last page of this document. And does it bear any signatures?
It does.
And are you able to identify those signatures?
I am.
What do you see?
Brittany Parker, who is a previous manager of Lakeview, and Michael White, the tenant in that home.
Thank you. I'm going to draw your attention to the top of this document, since this document does appear to contain 2 lease agreements. And do you see the date on page 1 of this document?
I do.
And when is this letter from?
April 7th of 2021.
And what would be the effective date of any information relayed in this letter?
The effective date was April 1st of 2021.
Do you know, or would you have reason to know, why this document has a printed date of April 7th when the effective date was April 1st? Do you have any reason to understand why this letter would have a later date than the effective date?
I do not know because I did not work here during that time frame, unless his lease had not been renewed by that time. So they sent this out to let him know.
And is that something that you have experienced yourself as a manager of Lakeview or of Sun Communities in general?
Yes, they send them out from our like corporate office, so they could have been delayed getting them out, but it would have been because they noticed that the lease hadn't been renewed.
And in this particular lease here, does it indicate a term?
Yes, April 1st of 2021 to March 31st of 2022.
And is this a lease agreement also between Lakeview and Michael White?
Yes, it is.
Is this also for the address 6274 Sheldon Street, site number 294?
Yes, it is.
And to your knowledge, is this lease substantially similar or completely similar to the prior lease agreement from 2020?
Yes, they're completely similar.
Thank you. I'm going to draw your attention again to the signature page. Do you recognize any signatures here?
I do.
And what are those signatures?
Brittany Parker, the former manager of Lakeview, and Michael White.
Thank you. Your Honor, I would move to admit this as Exhibit 1.
It's already been admitted.
Thank you, Your Honor. Your Honor, the next document that I'd like to have marked, and I again will describe it for Mr. White and for the court, is a similar letter that the parties have seen, which is a letter from December of 2024 mailed to Michael White, or indicating a mailing address for Michael White, and referencing a lease renewal effective April 1st, 2025. And I'd like to have this marked as Plaintiff's Exhibit 2.
All right, you mark it.
And Your Honor, just to further describe this letter, this is a letter, again, December 20th, 2024, indicating an offer of a lease renewal and indicating the applicable rental rate effective April 1st, 2025. And Michael White has no objection. I'd move to admit this as Plaintiff's Exhibit 2, and I will take additional testimony from Ms. Green as necessary.
Any objection, Mr. White?
No objection, Your Honor.
All right, thank you. It is admitted.
Thank you. Ms. Green, is this a standard document that is utilized for Lakeview?
Yes, it is.
What is the purpose of this document?
To give residents and tenants a few months to decide if they're going to renew their lease at the new rate they're being offered. So those go out 90 to 120 days in advance to their lease expiration.
Thank you. And in this document, does it indicate what will happen if a lease renewal is not signed?
Yes, it does.
What occurs if a lease agreement or a lease renewal is not signed?
The tenant will roll month to month, and their rental rate will be $750, and that will include a $39 month to month premium.
So in this particular example, is it accurate to state that this letter represents a monthly rental rate of $711 effective April 1st? And if a lease agreement or lease renewal is not signed, that the defendant in this particular instance would then also be responsible for a month-to-month premium of $39 per month.
Correct.
Thank you. I'm next going to draw your attention to this document, Your Honor. I would like to mark this as Plaintiff's Exhibit 3.
You may.
And I'll describe it for the court as well as for Mr. White. Your Honor, this is a document dated April 3rd, 2025, indicating it was addressed to Michael White at his address in the community. Subject line, month-to-month tenancy at Lakeview. And this indicates that based on records that it would appear he elected not to sign a lease agreement, and that effective that particular month, he would be responsible for a $39 monthly premium. And if Mr. White has no objection, I would move to enter this as Plaintiff's Exhibit 3 and take applicable testimony from Ms. Green.
Any
object, Your
objections?
Honor.
All right, it is admitted. You said no objection?
I do object.
Do object. All right, what is your objection on this one?
I never received the document that they're stating.
Your Honor, I would argue that this is a business record.
Any objection? All objections.
It is a document that is in Mr. White's file, and it is a standard document that is utilized by the property as well as by some communities in general.
All right, I would admit it over objection. Mr. White, you can testify yourself when the time comes to the fact that you did not receive it, so that it goes to the weight of the evidence, not to the admission of the document itself. That makes any sense to you?
Yes, Your Honor. Go ahead and proceed. Thank you.
Thank you.
Thank you, Your Honor. Ms. Green, do you recognize this document?
I do.
And as I indicated,
And excuse me if I'm a Matlock fan.
is this a document that is used in the ordinary course of business for Lakeview?
Yes, it is.
What is the purpose of this document?
This is to remind the residents that we did not get a lease renewal for them because they either neglected to sign it or they chose not to. So they are now effective month-to-month tenants, and that a premium needs to be paid with their rent each month.
There is a notation on here. It indicates if you would like to avoid this $39 premium or believe that you received this charge in error, please visit the community office or contact your community manager at a particular phone number. Does that mean that the month-to-month fee or the month-to-month premium may be reversible at this point?
Yes, it does.
Thank you. Your Honor, I next draw the court's attention, Ms. Green's attention, to what I would like to have marked as Plaintiff's Exhibit, I believe this is going to be Exhibit 4. And for the court's reference and Mr. White's reference, this is a letter dated December 29th, 2025, again addressed to Mr. White. indicating that effective April 1st, 2026, monthly rental rate would increase to $750 per month. And also, again, notifying defendant of a monthly premium. If Mr. White has no objection, I'd move to enter this as Exhibit 4 and take applicable testimony from Ms. White. Excuse me, Ms. Green.
I'm sorry. Any objections, Mr. White?
No, Your Honor.
Exhibit 4 is admitted.
Thank you, Your Honor. Ms. Green, likewise, is this a standard document used within the ordinary course of business for Lakeview?
Yes, it is.
And is this a document from Mr. White's file referencing an lease renewal offer and the applicable rate beginning April 1st, 2026?
Yes, it is.
And does this also indicate the monthly premium for choosing not to sign a lease agreement or for some reason neglecting to do so, $41 per month?
Yes, it does.
And to your knowledge, was this letter provided to Mr. White?
Yes, it was.
Thank you. And Your Honor, I would next Ms. Green, before we move on to the next letter, following issuance of this letter, did you have reason to understand that Mr. White did have an interest in executing a lease renewal for this applicable term?
Yes, because we actually hand delivered it to his home with sticky notes showing where he needed to sign, with in addition a note on it to say to return to the office by 3/25/26 to make sure it could be generated and put into the system so that he did not end up with any month-to-month charges if he chose to re-sign it.
Thank you. And who hand delivered that to Mr. White?
It was the day that the viewing of the driveway and the photos were taken. Maintenance, Austin McKeegan and Brian were there as well.
Were you present, Ms. Green?
I was not.
Okay. Your Honor, I will refer when I speak with Mr. Waginko regarding delivery of the lease agreement.
All right, thank you. Are you moving forward?
Yes, Your Honor. I would like to mark this next document as Plaintiff's Exhibit 5. And I'll describe it for the court and for Mr. White's reference. This is a letter dated April 3rd, 2026, and it is referencing being addressed to Michael White at his site in the community. And it also indicates that effective this month, he is responsible for a $41 month-to-month premium. And if Mr. White has no objection, I would move to admit this into evidence as Exhibit 5.
Any objections to White?
Was that document signed by anybody? Your Honor?
It appears that it's not.
Yes, and that's the exact thing, one of the things we've been talking about is, they say they notified me, but yet I have no record of it, nor that I know for a while they were trying to find the lease that I did sign that they weren't able to find. And I didn't sign anything after that until I was hoping they could find the lease that was missing.
All right, so this letter here is from April 3rd, which would have been just a few days ago in reality, so 2 weeks. Not even 2 weeks, 1 week ago.
And
Are you
while we're in the
objecting
middle
to?
of court proceedings, Your Honor, I wouldn't have signed anything unless I
I'm
could
not
have
saying
talked
you
to.
signed anything, sir. This is just the notice that you didn't. They're saying that you're being charged $41 per month premium. They're alleging that this is a notice that was sent to you. Who would have sent this to him? I guess I need that additional.
Yes.
foundation.
Ms. Green, can you clarify how these letters are generated and how they are sent to any resident in the community?
Yes, when a resident doesn't renew the lease and when they generate the report at our corporate office, anybody who hasn't re-signed for their new term will receive this letter via USPS mail.
From corporate?
Yes.
Thank you.
So, Mr. White, what is your objection exactly?
It's acknowledged that I received it, but I disagreed with it and was still hoping that they could find the lease that I did sign last, which is another thing that we had issues with this park. Or
Mr. White, you can testify to that
Yes,
afterward. It's not about that issue just yet, but you can testify to your disagreement with the fact that you hadn't signed a new lease. You can testify to that when your time comes.
yeah, that'll be fine, Your Honor.
All right.
I
thank
did
you.
receive that document.
All right, Exhibit 5 is admitted.
Oh, sweet Jesus. What?
Would now like to refer to this next document that I would have marked as Plaintiff's Exhibit 6.
Thank you.
And I'll describe this document for the court. Your Honor, this document is a ledger for Mr. White. It is a full accounting, 17 pages long, dating back to 2021. And I will inquire with Ms. Green regarding the facts and circumstances of this letter, take applicable testimony if Mr. White has no objection.
Any
No
objections?
objection, Your Honor.
It is admitted.
Thank you, Your Honor. Ms. Green, do you recognize this document?
Yes, I do.
What is this document?
This is a customer ledger and it's for Michael White at 6274 Sheldon Street, Site 294.
Thank you. I'm going to draw your attention to a few key items on here just so the parties understand what certain things mean. There is a notation up here in the corner. It indicates on 4/6/26 by D Green 3. What does that mean?
That means that this ledger specifically that we're looking at was printed on 4/6/2026 by me.
Thank you. This also indicates a lease start date of 4/1/21 and a lease end date of 3/31/22. What does that mean?
That means that's the last time that Michael White was in an actual 12-month lease term.
Thank you. This also indicates a move-in date of 2/1/19. What does that mean?
That would be the day that he moved in here to Lakeview.
Thank you. I'm going to scroll down to the very bottom of this page, Ms. Green. I'm going to draw your attention to something that may cause the party some confusion. This indicates some initial charges on the ledger, security deposit 2/1/19, which would appear to be consistent with his move-in date. Is that correct?
Correct.
This also indicates a balance transfer as of December 31st, 2020. Do you know what that means?
There could have been some type of balance transfer from another ledger, but because I wasn't here at that time, I would have to see if there's any notation somewhere else, but
Thank you. And Ms. Green, are you familiar with a rental management software called Yardi?
yes.
And are you familiar with rental management software called NetSuite?
Yes,
When did Lakeview previously utilize Yardi as rental management software?
they did.
And does Lakeview currently use NetSuite as their rental management software?
Yes,
Are you aware specifically when Lakeview converted from Yardi to NetSuite?
I believe it was in 2020.
And then would this draw a conclusion from you that this balance transfer may have been exactly that, the conversion of this account from Yardi to NetSuite?
I do believe that would be what that is from.
Thank you. And to your knowledge, does this document accurately reflect the charges made against and the payments made by Mr. White for his tenancy?
Yes, it does.
I'm going to draw your attention to a few more key items, Ms. Green. This document indicates that as of January 1st, 2021, the rental rate was $554. Is that correct?
Yes.
And does it also indicate that there are utility charges such as water and sewer that are charged to Mr. White?
Yes, it does.
And from your review of the ledger, are those static charges or do they change monthly?
The site rent does not change monthly, but the utility charges do based off of usage.
And how are those usage amounts determined?
The meters are read.
Thank you. Based off of what you're seeing here from 2021, is the defendant, Mr. White, being charged during this time frame for a month-to-month premium?
No, he is not.
I do see, let's go up to, you had testified a few minutes ago that the lease term went through 2022. So I'm going to bring you to that applicable time frame. That lease, that testimony you provided indicated that Mr. White was on an active lease through March of 2022. Do you see that Mr. White was responsible for a month-to-month premium beginning in April of 22?
I do.
What was the month-to-month premium as of April 1st, 2022?
$29.
And in reviewing this ledger, does this ledger reflect that Mr. White was a month-to-month tenant for the entirety of that applicable time frame? What would have been April 1st of 2022 through March 31st of 2023? And I will go slowly, so both yourself, the court, and Mr. White can see those charges. And I can highlight them here: June 1st, May 1st, month-to-month premium, July 1st, month-to-month premium. If I move to what would be the following term, Ms. Green, let me ask you this. Do residents have what community staff would refer to as an anniversary date?
Yes, it would be when their lease expires to the new lease starting.
And what would Mr. White's anniversary date be?
April 1st of 2023, or April 1st would always be like his anniversary date with whatever year we're in.
Thank you. So in referring to April 1st of 2023, do you likewise see a month-to-month premium?
I do.
And in scrolling through the year 2023 and rolling into 2024, are you likewise seeing month-to-month premiums for each month?
I do.
Now moving into 2024, which is one of the leases at issue here. Do you likewise see a month-to-month premium assessed to Mr. White in April of 24?
I do.
And are those month-to-month premiums charged throughout the time frame following his 2024 anniversary?
Yes.
In your time as manager for the community, Ms. Green, have you had an opportunity to review Mr. White's paper file?
I have.
And have you found any indication in that paper file that Mr. White has signed a lease agreement for the term of April 1st, 2024 through March 31st, 2025?
No, I have not.
In your time as manager of the community, have you had an opportunity to identify any loose paperwork around the management office?
Yes, any papers that were not filed when I started have been filed into the correct files at this time.
During that time frame, did you identify or locate any documentation that suggested that Mr. White signed a lease agreement for the term of April 1st, 2024 through March 31st, 2025?
No, I did not.
With respect to the current lease term, which began I'm so sorry. I was asking for 2024 to 2025. But let me likewise ask you with respect to the lease term from 2025 to 2026. Did you find any documentation in either Mr. White's file or anywhere around the office suggesting that a lease renewal was signed for 2025 through 2026?
No, I did not.
And do you have reason to believe that a lease renewal was generated and delivered to Mr. White for the current lease term of April 2026 through March of 2027?
Yes.
To date, do you have any information or have you received any documentation to show that Mr. White has renewed his lease presently?
No, we did not receive the lease back that we delivered to his home, marking where to sign the places. He actually had it earlier in these proceedings in his hand.
At present, is Mr. White responsible for a month-to-month premium?
He is.
What is
Yes.
that month-to-month premium?
$41.
What is his current site rent?
His current site rent is $750.
And is he still responsible for utilities such as water and sewer?
Yes, he is.
And are those utilities still metered based on usage?
Yes, they are.
How does a resident know what their utility usage charges are on a monthly basis?
They receive a yellow postcard in their mailbox from the National Billing Utility Service, and it shows them the breakdown for water and sewer usage with the amount owed monthly. They get a new one each month.
Thank you. With respect to Mr. White's tenancy, do you have reason to know of a dispute raised by Mr. White regarding his access to the mailbox?
I'm aware that he is disputing it, yes,
And how did you become aware of that?
through these court proceedings.
Has Mr. White himself or any individual on his behalf notified you as manager of any issue, alleged issue regarding access to the mailbox?
Not from him or his staff, no.
With respect to access to the mailbox, how does a resident in the community gain access to a mailbox upon becoming a resident?
When they move in and they're doing their lease closing with us or anyone that works in this office, they are told after their lease that they're going to take the lease that is signed by both them and us to the post office. They will fill out a form and the post office will then come out and change their locks and provide locks to them. The post office requires that they show their lease in order for the locks to be changed.
Have you, in your time as manager at Lakeview, changed the locks on Mr. White's mailbox?
No, we have not.
Have you directed any employee of the community to change the lock on Mr. White's mailbox?
No, I have not.
Have you yourself done anything to interfere with Mr. White's access to his mailbox?
No, I have not.
Have you directed any employee of the community to interfere with Mr. White's access to the mailbox?
No, I have not.
Have you directed any individual, even outside community employment, to change the lock or otherwise interfere with Mr. White's access to his mailbox?
No, I have not.
During your time as manager for Lakeview, have you been directed by the post office to change the lock for any resident in the community?
No, never.
Have you changed the lock for any resident in the community for their mailbox?
No,
During your time as manager for Lakeview, have you directed any other Sun Communities or Lakeview employee to change a lock for another resident of the community?
no,
During your time as manager for Lakeview, have you directed any other individual outside of Lakeview employees to change a lock for another resident of the community?
no,
Are you aware of any reason why Mr. White's lock would have been changed or interfered with?
no.
In reviewing this ledger, Ms. Green, can you clarify when the last payment was that you received from Mr. White?
We received an $800 payment from Mr. White on March 5th of 2026.
And prior to that, when was the last payment that you received?
That would have been on January 5th in the amount of $780.
And prior to that, when was the last payment received?
We did receive a payment on December 4th of 2025 in the amount of $780. But if you scroll up just a tad, on December 10th, that payment was returned to us for non-sufficient funds.
Thank you.
Mhm.
Based on the charges to the ledger and the payments made by Mr. White, what is the current balance due and owing by Mr. White?
As of today, the current owing is $2,995.30.
And are you seeking a judgment for that amount today?
I am.
To your knowledge, has the management office been delivered or received, otherwise received a payment from Mr. White for April of 2026?
No, we have not.
Thank you.
Mhm.
I am now going to draw the court's attention, Your Honor, to what I would mark as Plaintiff's Exhibit 7. Actually, Your Honor, I don't believe that Ms. Green took these photos. Ms. Green, were you at the property on March 18th when these photos were taken?
I was at the property, but unable to get over there at that time frame, and we didn't want to miss the appointment, so I sent both maintenance techs over.
Okay, Your Honor, I will save this for when Mr. Wikinka provides some testimony. Your Honor, that is the questions I have for Ms. Green at the moment, though I may have rebuttal testimony or even a redirect depending on how Mr. White's cross-examination goes.
Thank you. Mr. White, your opportunity to cross-examine Ms. Green.
Yes. Did you make a statement or any of your staff make a statement to your attorney that there was nothing wrong with my driveway?
Objection, Your Honor. It's gonna fall under attorney-client privilege.
Okay.
All right. You can't ask her what she said to her attorney because there's an attorney-client privilege. She can't.
Okay, Your Honor, let me change that.
The objection is sustained.
Did you have your own maintenance staff inspect my driveway?
Yes, both maintenance techs that work for Lakeview inspected the driveway.
And what was their conclusion about my driveway?
Objection, Your Honor. I'm gonna argue that that's hearsay and that he can cross-examine Mr. Waginko with respect to their conclusion.
Thank
Okay.
you.
We'll go ahead and do that.
All right. Based on his question though, ma'am, did you take any action based on recommendations from your staff regarding the driveway?
After I received the photos, I did direct a contractor to come out and quote for a new driveway.
And in the last 15 months, why do you not have other estimates to repair that driveway.
I'm sorry, Mr. White, I haven't worked at this location for 15 months. So when this was brought to my attention, we took the photos, and when I received the photos, I reached out to a contractor to have them come out and look at it.
Okay,
Miss,
and
when did you receive the photos? Miss Green, when did you receive the photos?
The same day that they were taken.
What day is that, please?
Let me check. March 18th.
2026?
Correct.
Thank you. All right, you may continue, Mr. White.
yes, and at any time before March, did you hear any complaints about my driveway not being fixed?
The driveway was brought up during court proceedings.
Is that a yes or no, Ms. Green?
No.
Okay. And in your vast experience as a property manager, have you ever found documents that were misfiled, like say their name started with the M, but yet it was filed in like the F's?
Just so I'm understanding your question, you're asking if there's been a time in my career with or without Sun where I have found things that have been misfiled. Is that your question, sir?
Yes.
Yes, I mean, things can happen like that.
So you do acknowledge things can be misfiled. Has there any been a time in your career where things were lost and you never found them?
Oh, he's got her on the run now. Oh, sweet Jesus. This is horrible. She's an excellent witness.
I'm sorry, I guess I don't know why he's asking about my career or.
No. And your vast experience as an office manager.
If there's an objection, you need to answer the question.
I'm sorry. Can they read?
No, I told her, Mr. White, unless there's an objection, she needs to answer the question.
I'm sorry.
Ms. Green, do you need
Yes.
this question restated?
Can you read? Yes,
She
please.
said the question, she didn't like the question.
I'm just asking Mr. White to repeat it, Your Honor. That is all. I think there's some confusion now as to what was asked, so Mr. White can restate his question. I'm not asking him to rephrase it, just to restate it.
Has there ever been a time in your career that things got lost that you never found?
No.
In your entire career?
She answered it.
No.
She answered it twice.
So
Ask again.
Come
on, Matlock.
I have office staff myself. They lost paperwork.
Your Honor, I'm gonna.
Right now, you need to ask questions.
Are you telling the court that in all of the years that you've been in office management, property management, that you never lost a single item?
The question you asked before was, have you ever lost anything that was never found? Her answer to that is she has not lost anything that she didn't find. Is that correct, ma'am?
Yes, it is, Your Honor.
Thank you.
All right, we'll move on, Your Honor. My chair staff, they did find the check that I made out for this month that it
Your
did
Honor,
the office, so I apologize. I do have it in my possession. and I did not deliver it to their office. Have you been privy to me getting a $700+ water bill?
Have you been what? Curvy? Pervy? I think he's going for privy. I'm not sure. It's not what he said.
A couple years ago?
Objection on relevance, Your Honor.
What is the relevance?
The relevance will show that mistakes have been made at that office and will continue.
The irrelevance will show. My Sunday's complete.
To be made at that office.
Your Honor, I still don't understand how that's going to be relevant to the case at hand.
For
I make an argument that, sir, please stop talking now. All right. His argument is that he claims he brought the lease agreement there and it was lost, and he's trying to show that mistakes happened in the office. I'll accept it for that limited purposes. You may ask the question, sir.
Were you privy to me receiving a $700 water bill a few years back?
No, I did not work here a few years ago.
Okay. And where I was billed over $700 for a water bill.
She wasn't present to it. You can testify later about that, but she can't answer it.
Yeah, I was just trying to show that mistakes have been made in the past from that office.
I understand what you're trying to show, but you asked her a question. She already answered that. If you want to testify to that later, you can, but she cannot answer that question.
I apologize, Your Honor. And again, please have a little patience
Yeah, we know what you're trying to do, but you're doing it wrong, and it doesn't matter anyway.
with me because I never went to law school.
I understand, sir. Thank you.
Thank you.
Wow, that's shocking.
And I did receive the letter that they're stating on April 3rd. I didn't sign the lease in the middle of this court proceeding to make sure I wasn't harming any part of my case. But I did receive it. I think that'll cover my cross, Your Honor.
All right. Thank you.
Hallelujah.
I have a couple questions for you, ma'am. So you indicated you did call out a contractor in March, correct?
Yes.
What is the status of that?
A quote has been submitted and approved.
And when is the work supposed to be done?
They're getting us on the schedule and they will let me know as soon as possible. I did follow up this morning prior to court to see if they had a specific date so I could disclose that. They did not, but they said they will get with me hopefully by the end of the day or not, or if not, first thing Monday.
And it's your testimony that the first time you heard about the sidewalk issue was during the middle of this lawsuit?
That's when it was brought to my attention that he had an issue with his driveway, yes.
And you testified earlier that there is a mechanism for providing your office with notice of issues, correct?
Yes, they can call in a work order or a, concern, or they can come up into the office and let us know.
And it's your testimony that you never received any phone calls or visits from Mr. White or his staff regarding this sidewalk issue before March of, before hearing about it in court?
Correct.
All right. Thank you. Any questions based on my questions?
Your Honor, just to clarify a few things with respect to the property's actions and the timeframes in which those were taken. So, Ms. Green, you've stated in your testimony that you became aware of Mr. White's dispute or concerns related to the driveway through these court proceedings, correct?
Yes.
And is it an accurate statement
Oh,
that
good Lord.
these proceedings began in, I believe the demand was issued in December? Let me verify. I believe it was January. My apologies, Your Honor. Is it a fair statement that this demand was issued in January, Ms. Green?
Yes.
And between January and March 18th, when you received the photos for maintenance, did you have an opportunity to observe Mr. White's driveway yourself?
I have driven over there to look at it. Yes.
Did you get out of your vehicle?
Yes.
Did you walk onto his driveway?
I didn't walk very far onto his driveway, but I was able to view it. Yes.
And when do you recall on or around what date that was? And if you don't remember the exact date, a general date would suffice. Was it before or after March 18th?
It was after. Or
And
I think.
do you have a recollection or a clear recollection of when it was? If it was before you received those photos or after you received those photos?
I believe it was before, because then I told them the area, because the vehicle had been moved, like not in the same spot it was the first time that we had driven by it.
Okay, so to clarify, there was a point in time prior to March 18th where you drove by, you observed the driveway. And at that time, do you recall what you noted the condition of the driveway to be?
Yes, because at that time there was a vehicle parked where these photos were taken, where we could not see this area of the driveway, where to what I could view from what I saw, the driveway was in okay shape. But then the vehicle was moved, and that's when we were able to see the issue.
Thank you. How many vehicles were in the driveway the first time that you had an opportunity to observe Mr. White's driveway?
One.
Can you describe its location when you viewed the driveway the first time?
It was up towards the front.
Do you remember if it was on the right side or the left side of the driveway when you are facing the home?
I believe it was more to the right side of the.
And is that closer to Mr. White's home or further away from his home?
Closer?
If you are facing Mr. White's home, is his driveway to the left of his home or to the right of his home?
To the left.
So you saw a portion of the driveway to the left of his vehicle,
Mhm.
or
and
a
like
vehicle,
and the very part that you like first pull over. Yes.
the ramp leading up to the driveway,
Mhm.
for lack of a better term. Okay.
Yeah.
The photos that will be introduced into evidence through Mr. Waginka's testimony, you had an opportunity to view those on March 18th. Is that correct?
Yes.
And those photos changed your position with respect to the condition of the driveway.
Yes,
Is
it
that a
did.
fair statement? And that is what drove you to then request a quote for driveway replacement. Is that correct?
Yes.
Ms. Green, have you seen concrete cement conditions that are in worse condition than Mr. White's driveway?
I have.
Is Mr. White's driveway what you would consider to be a safety hazard?
No,
Is Mr. White's driveway nonetheless in a condition that you believe warrants replacement?
yes, I can see that there's some form of issue. But we should have it replaced, yes.
Thank you. I don't have any further questions for Ms. Green, Your Honor.
All right, Mr. White, any questions based on my questions as well as Ms. Barber's question?
Yes, I have a few additional questions, Your Honor.
All right, you may proceed.
Okay, at any time in your history as being property managers, were you ever a concrete contractor?
No, I was not.
And if you had opinions about concrete, would you believe your opinion of it over a concrete contractor of more than 30 years experience?
I don't like to make opinions on them. I like to just call the contractors out who know that scope of business to see, what they feel or quote things.
Okay. And are you 100% sure that this issue wasn't brought up to you personally?
Mr. White, do you trust your opinion with respect to law matters more than an attorney? I'm just curious.
Prior to the date that you stated.
No, I do not have anything here.
Okay. Could it be possible that you forgot to write anything down?
If I specifically take a work order, it goes into the system as I'm taking the work order. So if it was called into me directly, then a work order would have been created in our NetSuite program.
Okay. And then your vast experience relying on your employees. Have you ever had an employee forget to give you something or forget to tell you something?
Yes, in my time as a manager, some employees have forgotten things. People are human. Sometimes they make mistakes or forget to pass things along.
Okay. And because this has been going on, are you familiar with Brittany, the prior office manager?
I am not. We did not work together.
Okay. Were you aware that I have a few witnesses here today that's going to testify that I've been making complaints about that driveway for the last 15 months?
You have stated you have people that have that have heard you make complaints. I've heard you say that, yes.
And they're here with me now. I'm just amazed at how efficient your office is, because
Objection, Your Honor.
that
Objection.
Mr. White.
go ahead.
Statements now. Do you have questions? You can ask questions, but you can't make statements.
Okay. Have you found any notes? I'll plug that in. Have you found any notes from Brittany in regards to my account?
No, I have not.
Okay. Your Honor, one of my witnesses has to leave like within the next 15 minutes. Would it be possible to have him testify before he leaves?
Ms. Dornbush, are you willing to allow his witness to go out of order?
I am, Your Honor.
All right. Are we done with Ms. Green? Any more questions for Ms. Green?
Just one, Your Honor.
All right.
Ms. Green, with respect to the condition of the driveway that you identified as warranting replacement, did you notice any large holes, cracks, divots, things of that nature?
No, I did not.
What would you describe the condition of the area of concern that warranted replacement? How would you describe that area?
It's almost as if it's like shavings or like turning to like gravel instead of like staying solid cement, but there's no like divots, cracks, or like holes. It's like almost like a deterioration into gravel almost.
Thank you. No further questions, Your Honor.
Anything based on that? All right. This witness may be excused.
Thank you.
We will now go out of order and allow Mr. White to present his witness who has to leave. What is, sir, please come to the screen and raise your right hand to be sworn.
Don't worry, there are only 15 witnesses.
Do you swear or affirm that the testimony, wait 1 second, I can turn on my camera.
Yes, I do.
I haven't given you the oath yet.
Oh, I'm sorry, I can't.
Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Now lower your hand. Please tell us your first and last name and then spell it for the record.
Gregory Phelps, last name Phelps, first name Gregory.
Thank you. All right, your witness, Mr. White.
Yes, Your Honor. Mr. Phelps. I mean, you had repeated conversations specifically regarding my driveway over the last 15 months.
Yes,
And was most of the conversations in regards to safety that I could slip with my crutches or one of my care staff can slip and fall or trip over the subsoil that weren't filled in?
yes,
And have you known me numerous times to go up to the office and verbally sit there and tell the office staff that same complaint?
yes. Through conversations, you have mentioned you have gone up to the office and mentioned the driveway.
And
Well, wait a second. Have you ever seen him do this?
No, I'm not with him, but he has mentioned to me several times that he has made complaints. I help Mike. He's a friend of mine, but I'm also like his maintenance staff. So I help like clean off his porch, take out his trash, and the top layer of it's really gravelly. I mean, when
Your Honor, I'm
say,
gonna object to that as well. That is outside of the scope of Your Honor's question.
okay, no, I have not been with him personally going up to the office, but he has called or texted me several times saying that he has done so.
Thank you.
okay. Is the surface of that driveway cratered up?
Yes, it is.
Is there a layer of gravel shavings from the deterioration where people can slip and fall, especially someone like me using crutches?
Yes, there is. Yes.
Was the side edge along my neighbor's side ever filled in where somebody could roll their ankle or trip and fall?
No.
And would you say at least 3/4 of the driveway is that condition?
Yes, it is.
And You seen different cars parked on my driveway from 1 car to 3 cars.
Yeah.
Could 1 car possibly block every single bad spot on that driveway?
No.
So, and I'm not going to have you, I'm going to drop the issue with the mailboxes, Your Honor. I'm going to drop that part of my complaint since I don't have adequate proof. Some of it would be hearsay evidence, which I'm aware now that you will not allow.
All right, thank you.
And this testimony here directly, impeaches the office staff. And
Objection, Your Honor.
What's the objection?
He's testifying as to what the relevance of Mr. Phelps's testimony is.
I think he can say he's offering it for impeachment purposes, just like you would be able to.
Well, I think he can say I'm offering it for impeachment purposes, but that's not what he's doing. He's making an argument and a conclusion with respect to it. If he wants to say I'm offering this testimony for impeachment purposes, he can say that, but he's not. He's saying this directly impeaches, which is testimony, not towards argument on his own behalf, not a statement with respect to the nature of the testimony being provided by Mr. Phelps.
I will accept it for the fact that he's saying he's offering it for impeachment purposes.
Understood, Your Honor. Thank you.
Your Honor, to speed things up and get him out here so he's not late. Does their attorneys have any questions for him?
So you're done with your questions, Mr. White?
Yes, ma'am.
All right, any questions, Ms. Thornwood?
Just very briefly, Your Honor. Mr. Phelps, are you employed?
No, I'm on disability, ma'am.
Prior to going on disability, were you employed?
I worked myself as a maintenance guy out in Ann Arbor. Yes.
And when you say maintenance guy, what did that type of work entail?
I worked in student housing. I paint, drywall, a little bit of everything, electrical, plumbing.
Are you a medical professional?
Am I a medical professional?
Yes.
No,
Do you have
I'm
any
not.
medical training?
No,
Okay. And are you a concrete professional or expert?
no, I'm not.
Nothing further, Your Honor. Thank you.
Anything further based on her questions, Mr. White?
No, Your Honor.
All right. May this witness be excused.
Thank you, Your Honor.
Thank you.
All
Thank
right,
you for
thank you
taking
very
this
much,
long.
sir.
I'll talk to you later. Go ahead, Your Honor.
I just said that witness is excused.
Yes, he's quickly throwing out his coat and running out the door.
All right. All right, we'll return back to the proper order. Ms. Dornbush, you may now call your next witness.
Thank you. Your Honor, plaintiff calls Austin.
All right. Mr. Wiginka, you've already been sworn in, and we have your spelling of your name. You may proceed. You're
Thank
still
you.
under oath, sir.
Thank you, Your Honor. Mr. Wiginka, are you currently employed?
Yes.
Where are you employed?
At Sun Communities,
And which community in particular?
Lakeview.
And how long have you been employed by Lakeview?
Roughly 9 months.
And what is your position at Lakeview?
Maintenance technician.
How long have, let me say this, prior to your employment at Lakeview as a maintenance technician, were you employed previously as a maintenance technician?
No.
In your time as maintenance technician at Lakeview, what are some of your duties?
Grounds. Making sure street signs are standing straight, work orders, ordering parts that we can replace. If there's something that we can't do, we contract it out.
And did you have, let me say this, are you familiar with the tenancy of Mr. White in the community?
Yes, I'm familiar with him. I'm from delivering the papers and stuff and just from being here daily.
Prior
get
to this
certain bases.
recent, oh, my apologies. Go ahead and finish your thought. I did not mean to speak over you.
Oh, no, you're all right. I was just saying, I see so many people here every day. I get to see some faces more than others. But yeah,
Prior to this recent court action, did you have any interactions with Mr. White to your recollection?
no,
As a result of these court proceedings, have you had reason to visit Mr. White's leased site?
no,
You have not visited Site 294?
no. He hasn't called in any work orders or anything like that. I just took the pictures and.
How did you take the pictures? Did you visit the site to take
Oh,
the
yes.
pictures?
Well, besides that first initial day, I took pictures, but I haven't been back to do.
Thank you. So you visited the site one time,
Yes.
and earlier testimony indicated that that was on March 18th. Is that
Yes.
accurate to you? What was the nature of your visit on March 18th?
To drop off the files and then take photos of the driveway.
And on March 18th, was there a vehicle in the driveway?
Yes.
Do you recall from your visit, if you were looking at the home from the street, where was the vehicle located?
Closer to the house. So like
Okay.
if you're walking up towards his porch, be like kind of like parked right next to it, I guess.
So the vehicle was closer to the home, to Mr. White's home, and not his neighbor's home.
Yes.
Did the vehicle get moved so you could view the driveway in full?
No.
And so your ability, were you able to see the entire driveway during that time frame?
On the day we took the pictures, yes. But
How did
since
you-
then there's been the car that's been parked in the same spot for
So how were you able to view the entire driveway if the vehicle was there?
we restate that question, please.
You said that you were able to see the entire driveway, but you also indicated there was a vehicle parked there, and you
Yeah, the
stated,
vehicle showed up after we had taken the photos.
okay, when you first arrived, you were able to view the entire driveway.
I need to take a
Yes.
brief break. One moment, please.
Thank you.
And audio?
All right, I apologize. That is sort of an emergent situation that I needed to handle. We back in session on Lakeview versus Michael White, 2016-0307. You may proceed.
Thank you, Your Honor. Mr. Waginka, I believe when the court took a brief recess, we were talking about your visit to the property, Site 294, on March 18th. And to clarify where we were at, when you first arrived at the property, was there a vehicle at the driveway?
Yes, it had moved. Were able to take our pictures, and then another car or nurse assistant had showed up.
Okay, so when you first arrived at the home, was there a vehicle sitting on the driveway?
Yes, but they were getting ready to move.
Okay, and
They were
was
like
that,
transitioning, one coming in, out, one going.
okay, so there was one car in the driveway and one waiting to enter the driveway?
Yeah, we were able to take our photos, and then another car pulled in shortly after.
Okay, and the individuals that were driving the vehicles, were either of them Mr. White, or did it appear to be some of his care staff?
Care staff.
And was the vehicle that was parked at the site when you first arrived parked fully on the driveway? Was it parked partially on the driveway? Describe its location, please.
They kind of shifted towards the center because we had gotten out and were standing and taking photos, and they tried to give us room to do what we needed to do.
This was the vehicle that was already parked or the vehicle?
No, the
that-
one that left, we had swept up a little bit of area that we had took a photo of. Throw it in a garbage can, you got the little bit of debris out of the way, just so they could walk in without tracking any dirt or mud on it.
So the vehicle that was in the driveway when you first arrived, before you took your photos, where was that vehicle situated?
I wanna say right there by the porch.
Was it fully on the driveway? Was it partially on the grass area?
I wanna say it was all the way on the driveway.
Okay. That vehicle left, correct?
Yes.
You were able to sweep the driveway some so you could take pictures of the driveway,
Yes,
and then a new vehicle arrived.
correct.
And they then parked where in the driveway?
A little bit further away from the porch.
So as to give
Not in
you,
the same spot as the car that had moved, but general in the same area.
okay. And you took photos of the driveway, or did Brandon take the photos of the driveway?
That would be Brian.
Well, Brian, I'm so sorry. Brian took the photos. I'm going to show you what I would mark as Plaintiff's Exhibit 7. Your Honor, am I still screen sharing or did that turn off?
It got turned off. You need
Did
to go back to
Okay.
sharing.
I didn't see the green line around it, so I had a feeling maybe it was gone. Okay. This is what I would mark as Plaintiff's Exhibit 7. Mr. Waginka, do you recognize these photos?
Yes,
What are these photos of?
his driveway.
Do these photos accurately depict the condition of Mr. White's driveway the day you visited the site?
Yes.
Your Honor, I would move to admit these as Plaintiff's Exhibit 7.
Any objection to admission of those photos, Mr. White?
Impossible. He needs to unmute again, Your Honor.
Mr. White, you need to unmute, I'm sorry.
Hello?
Yes, Mr. White, any objection to those photos?
No, Your Honor, but I would like to bring one photo back up at a later time.
Okay, thank you. Exhibit 7 of the photos is admitted.
Thank you, Your Honor. Mr. Waginka, looking at this first photo of Exhibit 7, can you tell from the photo and your recollection what area of the driveway this photo is showing?
That would be right behind where the car was parked by his porch.
So is this area closer to the street or further up the driveway?
Further up the driveway, closer towards the house.
Thank you. This photo, is this the same area as photo number 1?
Yes.
And what is this area right here?
That looks to be where they had like the edge of the driveway.
Okay, and off the edge of the driveway, what is this area?
Grass or dirt right beside the house, I would imagine.
Okay, thank you. This is picture number 3 that is part of this stack. From this photo and your recollection of the site, what does this picture depict?
The far side of the driveway. Like
Is
close to
this
the
side
neighbors.
here closer to the street or the home?
The side where the arrow you're touching at is closer towards the street. So if you rotate it, the grass would be essentially closer to the neighbor's house.
So this is the neighbor's grass right here.
Yeah, that's the yard. Yes.
Thank you. And I've changed the orientation, so let me switch it back to its
That was just
original. Yep, I think this is the original way that it was posted. What area is this?
That was just the edge. We brushed it off a little bit so we could get a better picture.
And is this on is this Mr. White's grass or is this the neighbor's grass?
That would be his yard.
So where is this at in relation to his home?
If you're standing at the street, that's about the middle of the driveway, walking up to his driveway on his yard.
And so his house is somewhere located on
To the
this
right.
grassy area. Okay.
No, his house is on the opposite side. So his neighbor's house would be where the blue shaded area is.
So
He
let me.
doesn't have much of a grass on the house side.
So this is Mr. White's grass or his neighbor's grass?
Well, he has his driveway and then they got about 5 feet of yard and then 3 feet of that is the neighbor's. So I guess you could say that's his yard.
Okay, but that's on his neighbor's side.
Yes, on the neighbor's trailer side and then you got his driveway, his house.
Understood. Thank you for the clarification. And Mr. Waginka, during your time at the site on March 18th, did you observe any large cracks in the driveway?
No, it's just more like how Dana described earlier, like a flaking. And then like we swept it and you could tell it just crumbled.
And after you swept it, did you notice any large craters or large holes, things of that nature?
No.
Was it excessively uneven? I'm sorry, Mr. Waginka, I did not hear your response.
No.
Thank you. In your time as maintenance at Lakeview, did you ever make any statements to Mr. White regarding the condition of the driveway?
No.
Thank you. I don't have any further questions for Mr. Waginka, Your Honor.
Your witness, Mr. White?
Yes, Your Honor. Sir, when you seen the section of the driveway that was along my neighbor's house, that's where the 2x4 framework to hold in the new concrete one was poured. That when the contractor pulled it out, it was never filled in. And if you look at how deep and how much lower that ground is to
Your
the,
Honor, is there a question? I'm gonna have to
I'm getting
object.
to it, Your Honor. That is that trip hazard more than an inch deep?
Yes, given the amount of water and rainfall that, yeah, I would easily say that's an inch.
Okay. And that driveway you said was crumbled on top. Like, do you recall sweeping up part of it to
Yeah,
see
we
how
did a good
deep
picture.
it went?
I'm sorry, what?
Do you recall sweeping up some of it with a broom and dustpan to see how deep it was crumbled?
No, we swept I think it was a 4x4 area for a photo reference. I don't remember sweeping for depth. I just remember sweeping one of the clear patches for a clear photo.
How long have you worked maintenance
Um,
at any site?
this is my first maintenance technician position.
Okay. And in your experience, have you run across any other driveway that was as worse as mine?
In my time being a maintenance man, no.
Exactly. So, are you aware of city, state, and federal housing guidelines in regards to tripping hazards of concrete?
As worse as mine, it hurts.
No.
The government, in regards to that question, I'll answer it for you. 3/4 of an inch.
Objection, Your Honor.
Okay. Were you aware that I was on crutches?
No.
Okay. And looking at that hazard there, is it possible anybody, even in good health, could trip on it?
Objection, Your Honor, calls for speculation.
Any response? He says that it's speculation, sir.
I'm sorry, Your Honor. No further questions for this witness.
Well, as to the question calling for speculation, I think he can have an opinion as to whether or not someone could trip on the driveway as it's currently existing. He is the maintenance man, correct? Doesn't he make decisions about things like that?
I don't know. Ms. Green, I'd have to ask Ms. Green or Mr. Waginka, whether or not he draws those conclusions or if they are referred to management or higher authorities to make assessments regarding that. Mr. Waginka, would you make those conclusions on your own or would you refer them to somebody else?
No, we just collect the information and refer it to our higher authorities.
Thank you. All right, you have any further questions, Mr. White?
No, I do not, Your Honor.
Thank you. May this witness be excused?
Yes, Your Honor, I have no further questions. Thank you.
Thank you.
And Your Honor, plaintiff has no further witnesses.
All right, plaintiff, what rest?
Aside from any rebuttal, yes, Your Honor, plaintiff rests.
Thank you. All right, Mr. White, do you have any further witnesses or are you prepared to testify at this time? I think we need to take a break. And then we'll come and start your case. Okay, Mr. White?
Yes, go ahead, Your Honor.
Give me about 3 to 5 minutes, please. We'll be in a break recess.
Thank you, Your Honor.
Attention, esteemed viewers. If you are hearing this message, it means that you are sadly witnessing a dark moment in the history of legal discourse. Yes, it's true. Law Talk with Mike is experiencing what we in the business call a plot hole-sized lull. This is, of course, due entirely to Mike's, let's say, ambitious approach to preparation. And by ambitious, I mean utterly devoid. Yes, the very fabric of our legal system, as represented by this live stream, has encountered a, shall we say, temporal anomaly. A glitch, a hiccup, a veritable vacuum of action. And who is to blame? Why none other than our esteemed yet woefully unprepared host, Mike. So sit back, relax, maybe grab This musical interlude is just gonna be a thing. We'll get back to the legal stuff eventually, probably. So to fill the gaping void where insightful legal analysis should be, and due to a lack of any ability to keep your attention, Mike has in his infinite wisdom decided to subject
Michael
you
White,
to
on
this
behalf of myself.
artistic expression. God
All
help
right,
us
I think we're at the stage, Mr. White, where it's your time to give your testimony. Please raise your right hand to be sworn.
Let me reset my phone, Your Honor. It slid down.
Okay.
There we go.
Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. All right,
Oh, this is gonna suck.
you can reset your phone if you need to set it better. So I can barely see your face.
I realized why it was down. She plugged in the phone charger on me, realizing the battery was going dead.
I see. Gotcha. Thank you.
Thank you.
You may proceed with your testimony, sir.
Yeah, we don't care.
Your Honor, at this time, can I tell my qualifications as a cement contractor?
Any objections?
No objection, Your Honor.
You may proceed.
Thank you, Your Honor. I have over 30 years in the concrete industry. And my business partner, he has a residential builder's license that we operated under. On new concrete, I haven't had a single warranty job. I know the state housing guidelines, federal, and everything in regards to it. And when they pulled the forms, they never filled in the dirt. Them forms are 2x4s. But what most people don't realize is they're not 4 inches thick. They're only 3 5/8 of an inch thick.
I don't know how to put this, but I'm kind of a big deal.
And by never filling in that ground, everybody that came in on that side of the driveway on a double wide drive, it put their safety in risk. And as you heard from their maintenance guy, he's seen several care staff coming in here. Now, I watched them do that concrete. I told the office what they did wrong from the very beginning was they boat loaded it, floated too much water to the surface, and then it froze below freezing temperature that night, which caused the upper layer of the concrete, which was thinner and more brittle before it could set up, to start crumbling like gravel. I let the office know that. I even told them how to execute a warranty on it to make sure that they sent text messages or sit there and do certified mail to prove when they were trying to execute the warranty. And they failed to do so, resulting in my driveway never being fixed. And the only way to fix it at its current deterioration is to tear it out and pour new. And if they just listened to me at the beginning, they would have had it done under warranty and not had to pay to do it over again. Secondly, with that layer crumbled on top into gravel, it's very dangerous that people can slip and fall, especially somebody like me on crutches, where my crutch can slide out and then I would sit there and flop to the ground. And so it is a huge safety concern. It violates city, state, and federal housing guidelines in regards to trip hazards. And if they have any HUD housing in this community, they deem any trip hazard as being 3/4 of an inch or deeper. Some jurisdictions have it 1/4 of an inch. I'm going to present another witness to testify, since she's been here, that I made numerous attempts to get it fixed.
Mr. White, before you do that, sir, do you want to testify at all regarding the lease and the payments or any of that stuff?
Yes, Your Honor. I was on a month-to-month lease when I wasn't sure if I was going to be in a nursing home or not. And then my health actually got a little better, which I wouldn't have had to go into a nursing home. But then unfortunately it got worse to where I wasn't able to move into my permanent retirement home. And so when I turned in the lease that I signed, I didn't really look at anything coming from the office. Just whatever they said I owed, I just paid. I got plenty of money. And I guess, I should have paid better attention to it, or I would have realized that they've been charging me more money. And when they charged me certain fees and didn't notify me that they charged the fee that month, well, then the amount that I paid wasn't enough to cover. So then they charged me an additional fee for being late, for not paying the entire amount that was due. But I asked them numerous times to text message me. I have over 3,000 emails to my old email site, and I didn't want to spend days trying to find something somebody might have sent me. So I asked them numerous times to text message me to notify me of anything. They failed to do it. And then they were charging me more and more money as a result of it. And it's just so frustrating that everybody wants to pass it on to the people before them. And that's why I was very specific about, if they had anything in the file from the old management. Because, when you're dealing with 2 and 3 different managements in a 2-year period, it's getting insane. It's getting insane that they're charging this fee, which they didn't notify me of, and then charge me a late fee because then the amount I paid wasn't enough to cover everything. And it's just, I know specifically that they rode by on their golf cart, took pictures from the street, and then they said there's nothing wrong with the driveway. Well, then you hear from their own maintenance personnel that there was. And I'm thinking, like, a lot of this, the right don't know what the left is doing. And they need to think about the way they're doing things, because to me, I feel they're trying to domino these fees into more fees in order to generate more revenue. Meanwhile, people like me that have a legitimate complaint that their driveway is a violation of state, city, and federal housing codes gets neglected, and I have to ask repeatedly, dozens of times over a 15-month period, trying to get it fixed. And since I do not own the property here, I can't just tore that driveway out and have my own employees come in and fix it, because I do not own the property that this trailer sits on. And nor do I feel it would have been fair for me to have to pay for a repair for something they should have done close to a year and a half ago. And I have one more witness to testify in regards to how long I've been waiting to have this driveway fixed. But if their attorney wants to ask me questions, by all means do so.
Darvish?
Thank you. Your Honor, just a few questions for Mr. White. Mr. White, you testified that you watched the driveway being poured. When was that?
That was in November.
It was good for putting people to sleep.
15 or 16 months ago.
So you are alleging November of 24?
November 24th to November 25th. Yes.
Okay. Who did you tell in the management office your concerns?
The office manager that was currently up there.
What is that person's name?
I think it was Brittany at the time.
And you say you verbally told Brittany?
Yes.
Did you submit anything in writing to the management
No,
office?
I even told her to make sure that she texts the company that did it and send certified mail as proof that they were asking for a warranty within the 1-year warranty period.
And did you have an opportunity to see whatever contract the management office had with the contractor who poured the cement in 2024?
She told me that he's not responding to any of their phone calls, and then I reminded her again to text him.
But did you see the contract to know if a warranty existed?
It's standard 1-year warranty in the state of Michigan for cement contractors.
And what's that applicable? Do you know that statute?
No, I haven't had to think about that in 30 years, but I do know this. The reason why the warranty is that low, because we live in a state with a freeze-thaw cycle, and that greatly affects the subsoils underneath the concrete. It could heave the concrete up during the winter freeze, and it could lower it back down in the spring thaw. And it could also wash out the subsoils. That's why there's only a 1-year warranty with the vast majority of the contractors.
Thank you, Mr. White. You indicated that HUD housing has a standard of 3/4 inches. What is that standard?
HUD housing, VA, loans for housing, that there cannot be greater than 3/4 of an inch trip hazard, or you cannot get the loan to purchase the property.
Got it. Is your property, the site that you lease or the home that you own, involve HUD housing?
That's why I asked earlier if they had HUD housing here.
No, I'm asking you, sir. Does your site involve HUD housing?
I don't know. I don't own the property that this sits on.
to purchase your home, did you obtain a HUD loan?
No, I purchased a home and paid cash. And for a year or two, I actually used it as a field office where I had dual residency, one in Wyoming, a suburb of Grand Rapids, and then basically here. So whatever part of the state I was working more on, I had a place to stay at either way.
Understood. You indicated that you referenced they drove around on the golf cart and took pictures. Who is they?
The office employees, but they didn't state exactly which one it was. So
Which office employees were
of
they,
Lakeview.
Mr. White? I understand
Of
that, but
Lakeview.
who was on the golf cart?
I don't know. I wasn't there watching them.
So so that's hearsay testimony. You heard from somebody else that they were at the property on a golf cart?
So somebody there in the office told me that they went by on a golf cart and said there was nothing wrong with my driveway. And they also relayed that to you.
When was this?
You have to understand, I'm recovering from a severe traffic crash. For the last 4 days, I haven't been able to get out of bed. So it's not like exactly like I have my secretary here taking notes for me.
Your Honor, I just have to strike that as ask the court to strike that as non-responsive. Okay.
So, just so that I'm clear, Mr. White, you didn't see the people on the golf cart. Someone told you that, correct?
Somebody up at the office, Your Honor.
That is hearsay. I will strike that.
Thank you, Your Honor. Mr. White, you with respect to your use of the site and your care team's use of the site, would you state that your use is done with care?
I don't understand that question. Are you asking me, do I need caregivers?
No, sir. I'm asking when you use the site, your use of the site, your treatment of the site, your care team's treatment of the site, the real property that your home sits on.
Yes.
Is there care taken, or would you say you and your team are negligent or reckless in your use of the site?
Nobody that comes here is negligent or abusive of any part of this property, both the outside, which Lakeview owns, or the inside, which I own.
And so you would take the position that you adhere to the community rules and regulations with respect to your use of the site?
Unless there's a rule or regulation that I'm not aware of, I try my hardest. I never had a complaint by a single neighbor in 7 years living here. And this is the only issue I had with this park is under the current management of it now.
Okay. And so again, your position is that you have utilized the site in a manner consistent with the lease or the rules and regulations.
Yes.
I'd like to draw your attention to, bear with me one moment, Your Honor. I realize the screen sharing went down again, so This is Plaintiff's Exhibit 1, Your Honor. And Mr. White, and this is page 10 of that whole packet. This is the community rules and regulations, Your Honor. It says Lakeview MHC community rules and regulations. And I'm specifically drawing Mr. White's attention and the court's attention to this section regarding automobiles. Subsection A. Your Honor, ordinarily I would ask Mr. White to read it. I don't know if he's able to do so or if the court would just like me to read that into the record.
Are you sharing it again?
I thought I was screen sharing it. Hold on one second, Your Honor. I am now. There we go. Mr. White, are you able to see the section I'm referring to? I'm going to highlight it here. Do you see this section?
Yes,
Do you see subsection A here?
yes.
Are you able to read that section?
Parking of vehicles is not allowed on vacant sites, fire lanes, lawns, or patios.
Have you adhered to that section? You and your guests, you and your visitors or care team, have you
I
adhered to that
I
section?
have only one of 4 sites on my street that has a double wide driveway. So 2 cars can be parked side by side, but I put up a little guardrail along my patio because somebody struck it about 5 years ago. To make sure that didn't happen again, I gave up a parking spot and put up a guardrail system. So I can only get 3 cars.
Okay. So your testimony today is that you adhere to this section of the rules and regulations. Is that correct?
Yes, and every vehicle I ever parked that I owned was legally licensed and tagged at all times.
Your Honor, I'm going to offer this next photo for impeachment purposes only. This is not a document that was previously provided to the court, nor was it provided to Mr. White. Mr. White, is this your home here?
Yes, it is. And that car's tires are sitting on patio blocks that I widened the drive utilizing. So it's not on the grass. And if it was, it's from somebody coming to visit me because I have a dark charcoal gray Ford Fusion that was totaled out in a car crash back in December. And if I'm unaware of somebody parking wrong, it would be immediately addressed. But they are on patio blocks that line in between the grass and the driveway.
Mr. White, you understand that you're responsible for the behavior of your guests and your visitors?
Yes, and they are not parked on the lawn. They're parked on patio blocks that I installed instead of the dirt pothole that used to be there.
Okay. Your Honor, with respect to, let me pull up the ledger. And so, Mr. White, it was your testimony.
What time is it?
27, I gotta get going.
Oh, hold on.
Do you need a moment, Mr. White?
My last witness has to leave.
Your Honor, I don't have an objection to pausing my cross-examination if Mr. White wants to call his last witness.
I will let you call your last witness, Mr. White.
All right. Hey, Rebecca, can you come in here, please?
Yeah.
All right. Good. And Your Honor, it's showing me pictures of 2 little
Yep,
baby
I'm
kids.
turning that off, Mr.
I don't
White.
have any children.
They're down now, sir.
Right. Go ahead, and they're gonna ask you to be sworn in.
All right, please raise your right hand and be sworn. Do you
Nobody
swear or
said you
affirm
had
that the
kids.
testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please state and spell your name for the record.
Rebecca Moore, REBECCAMOORE.
All right, thank you, Ms. Moore. You may question your witness, Mr. White.
Rebecca, is that your car that they just showed me a picture of, the silver Fusion?
I had a gold Fusion. I didn't have a silver one.
The
I didn't
picture
see
is
the
down.
picture, so I don't. I
Shit.
had a
It
gold.
might have been my eyes, but whenever you parked where I used to park,
Mhm.
was that on the grass, on the driveway, or on patio blocks that were
I parked right on the
installed?
edge of your grass.
The patio blocks?
Yeah.
Okay, but not on the grass?
Ma'am,
I
you
never
need to
park-
come
I don't
to the
park on the
microphone,
grass.
please. Everyone, please stop. Ma'am, you need to come closer to the screen so that we can pick up your testimony.
I'm sorry.
Here.
No, I don't park on the grass. I park next to the patio blocks. When I pull in, I usually back in right next to the patio blocks.
Miss Dornbush, could you please put the picture of the car back up that you just put up?
I can. Yes, Your Honor, give me
It
one
showed it
moment.
on the patio blocks, but is that your car that they're pulling up?
1 second, it's not up yet, Mr. White.
Oh.
Yeah, that's mine.
And are you on the patio blocks or are you on the
I'm on
grass?
the grass that time, yes. I am on the grass that time. I can say, yes, I am on the grass when I backed in.
Okay, and is that a common occurrence for you or is that like,
No, that was just an accident. Was just backing in.
okay.
Might have
So
been-
one-time occurrence?
Yeah,
And Your
Yes.
Honor,
I don't have that car no more.
you know, you could go down the streets here and see cars
Mr. White,
parked,
you can't, Mr. White, you
Okay,
can't
hold on.
testify right now.
right? You see my neighbor parked on the lawn.
Right, any other questions for this witness, Mr. White?
Yes, I do. Rebecca, have you ever seen cars fully parked on the lawns in this community?
Yes,
Thank you. Now, in regards to my care, you started taking care of me around August,
beginning of September, yes. Of
somewhere,
last year.
somewhere in that period of last year? All right. And have you known about my longstanding dispute with the office in regards to my concrete?
Yes,
And during that time, did they repair the concrete?
no,
Now, sometimes you park on the other side of the driveway, is that correct?
yes,
And where they pulled the forms out where the grass and dirt is a lot lower than the concrete.
yeah, because I've almost fell.
You almost fell. Okay, and do you see that as a safety issue?
Oh, yes, especially at night when I'm leaving. It's
Okay.
dark and I can't see.
And you could are you saying you could very easily trip, fall, and get hurt?
Yes,
No additional questions for this witness, Your Honor.
All right, questions, Mr. Dornbush?
I don't have any questions, Your Honor.
Thank you for allowing this witness also go out, because I'm pretty sure we all thought that we'd be back to our regular lives again.
Thank you, you are excused, ma'am. All right, we'll return to Mr. White's testimony. I believe you were asking questions.
I was, Your Honor, thank you. I believe where I left off, Your Honor, was, and bear with me a moment while I pull the document back up. And share. Okay. Mr. White, I believe your testimony was, and correct me if I am wrong, but your testimony was your belief that you had signed a lease agreement for the term of April 1st, 2025 through March 31st, 2026. Is that correct?
Yes, and it was turned into the office.
Who was it turned into?
I'm not sure of her name, but it wasn't Miss Green. So it was one of the secretary staff there.
And who turned it into the office?
Back then, I was still able to get around pretty good on my own, and it was me.
And you handed it to this person directly?
Yes, as you come up to the little door, and it's a half door that had a ledge on it. As you look straight ahead, it was the person at that desk. I know Miss Green's office is around the corner to the right.
Do you recall what day you turned that in on, sir? Give or take. I know you may not remember the exact date.
No,
so
I cannot.
I'll fault you for not.
I mean, it was over a year ago, and
Was it before or after the new lease term started?
I got it before the lease term started, and looked it over, and then signed in the appropriate boxes. Then double checked to make sure I didn't miss a signature anywhere. Then took it up there and dropped it off.
And did you retain a copy for your records, sir?
No, because I don't have any copying equipment here, and my office is on the other side of the freeway, about 15 to 20 minutes away. I didn't have a chance to zip to my office and make copies of it.
Okay.
So I signed whatever copy they gave me, and that's the only copy that they gave me.
And your testimony was that the community was charging you late fees as a result of the month-to-month fee. Is that correct?
As a result of the month-to-month fee, they have charged me late fees on that.
I'm asking you, sir, is that your testimony? Is that they were charging you late fees?
I'm not sure, because keep in mind, I got thousands and thousands of dollars in different bank accounts. And a lot of times I get lazy and I just ask them, what do I owe you? And whatever they tell me, I wrote a check for.
So at that point, you were willing to accept whatever charges management told you was due and owing.
Or if I was legally entitled to pay it, I would have, of course. But not anything that wasn't my fault, which them losing the copy of my lease, in my opinion, is clearly not my fault.
Are you aware, and I'm going to refer to your ledger here, that in August of last year, management credited back several charges, late fees and whatnot on your account?
I wasn't aware of it, but if you're telling me they did it, I have no reason to dispute it.
And following that time frame, were your payments taking into account the month-to-month premium?
Almost every month, I called up to the office. I asked them, how much do I owe you? So I can make out the check.
And did you question any of those months what the balance consisted of?
Well, the reason I did that, to make it clear, is because our water and sewer bill varies differently each month. So I wanted to make sure that I was paying usually more than enough to cover what I owed and then have a credit.
But don't you receive that information mailed to you?
The water sewer comes on a postcard, okay? But sometimes when I'm shredding thousands of documents, that water sewer card might be in between them, and I shredded it.
I understand. Okay. Mr. White, with respect to the current lease renewal, you have elected, as you stated, not to sign it yet because you were worried about it affecting your legal rights. Is that correct?
Correct.
So you are agreeing that for the month of April, you are a month-to-month resident and that you will continue to be a month-to-month resident until either you elect
I'm
to
right here.
sign the lease agreement,
I don't have
or
much
you
at
would
all.
remain a month-to-month tenant if you don't. I mean, there's going to come a point where a decision is going to have to be made. Are you intending to sign the lease or not?
The lease that I signed and delivered to that office for the period of 2025 to 2026, that I was being overcharged $39 a month as a result of them losing that lease. Now, if it's something I did, I have no problem paying the late charge. And to give you an example of that,
Mr.
they
White,
had a not sufficient
Mr. White,
funds.
Mr. White, sir,
Yes,
I'm gonna tell you what the law is on something so that you can understand it. You have a duty to mitigate your damages. Okay? What that means is, if they lost the lease and there was a new lease that you could sign, you can't wait until the end of the term and then argue that you should be refunded all the money because you should have just signed a new lease once you knew that it was lost. You have a duty to mitigate your own damages.
and again, Your Honor, I was unaware of that because I didn't go to law school.
I understand. But I'm telling you now.
Yes, ma'am. I mean, if you want, I'll sign the lease now and have someone take it up to the office.
I can't give you
In other words, you're losing.
legal advice. I can only tell you what the law is, and I'm telling you what the law is in the context of the statements you're making today. So you can be fully aware of what you're testifying to, as well as to the fact that what it could happen and what could happen in the future. I can't give you legal advice or tell you what to do about your lease.
Yes, ma'am.
And Your Honor, at this point, I don't have any further questions for Mr. White.
All right, Mr. White, is there anything else you would like to say based on the questions that you've been asked by her at this point?
If nobody drove by a golf cart and took pictures of my driveway, how did maintenance know they come by my driveway and inspect it?
Is that a question for somebody? Or is that, I'm not sure what you're trying to say right now. I mean, I know what you said. I'm
Well-
just trying to figure out if you're making a statement. Are you making a statement?
No, that is a question. If nobody came by,
But
and
no, you're the person on the stand, so you can't ask questions while you're on the stand. You can make statements.
okay, I'll make a statement. Since maintenance showed up here to inspect my driveway, that should be proof that somebody at a prior date was aware of the complaint, and just it's just so frustrating that they'll sit there and take a picture on one day that a caregiver came in here and parked that was maybe 6 inches on the grass, when there's entire vehicles parked on the lawns in this park on a daily basis. And I was just wondering why they didn't provide all them pictures of them other cars. That the entire car was parked on the grass.
Well, it's not relevant,
But
mostly.
So, Your Honor, I have the check here for $800 for this month's rent. I know there's going to be justifiable late charge on that because I wasn't aware that my care staff didn't take it up to the office. I have no problem paying that. And earlier, I had a money transfer from one bank to another so I can pay my rent and bills with that. And it didn't go through on time and it bounced the rent check. I have no problem paying not sufficient funds, late fee, and all that. But what I do have a problem with is these domino effects of their fees, that you're paying more and more money and nothing gets done. I shouldn't have to beg that office for 15 months to repair a driveway that violates state, federal, and housing guidelines, and it's a safety issue for me.
Yeah, pay your rent or get out.
And every care staff that comes in here. I have 3 shifts of care staff and 2 nurses coming in here on a daily basis. And I shouldn't have to be put through the frustration and aggravation and worry that somebody is going to trip and get hurt coming onto this property site.
All right, let me ask you a question. How many times have you notified them of the issue?
Dozens.
And
At-
what method?
At
By
least
what
once
method?
every month.
By what method?
I was coming up there in person.
When is the last time you went up in person, sir?
I was in a bad traffic crash in December of last year. And I was in the hospital for 6 weeks.
Okay, so when is the last time you went up there, sir?
I would say November. Either November or December.
You know who you spoke to when you went up there last?
There's a bunch of different people. There was one young African American girl there. I forget her name. And she used to be in the desk as you're facing into the office. Several conversations with Brittany. Nothing got done.
Brittany's been gone for a while,
Yes, I'm aware of that.
at least since, I think, Ms. Green testified she came in July, I think, as a temporary.
Then there was a girl there. She was real thin, petite. Her husband drove a white Ford pickup truck. Because I remember talking to him. And she pleaded with me that she was new and that everybody's been yelling at her all day over the problems. And so I told her, don't worry, even though we have issues, I'm talking, softly. I'm not trying to yell or scream at you. And I felt really bad for her because everybody else that day obviously was.
Thank you. Ms. Dornbush, any questions based on my questions?
Mr. White, did you submit any written letters to the community management office detailing your concerns?
No, I came there in person, addressed them in person.
And you've indicated in your testimony the bulk of your complaints went to Brittany Parker.
I say probably half of them. I have a crushed right hand. I only have 2 working fingers. It's hard enough just signing it and making out a check. I would never make out a letter, not even if I was writing it to my own mother.
I don't have any further questions for Mr. White, Your Honor. I do, though, have a couple questions for Ms. Green for rebuttal purposes.
All right, thank you. All right, Mr. White, thank you for your testimony.
Thank you, Your Honor.
I'm going to call your rebuttal witness at this time, Ms. Dornbush.
Thank you. Your Honor, plaintiff recalls to Ms. Dana Green for rebuttal purposes.
Ms. Green, you're still on the oath. You may proceed, Ms. Dornbush.
Thank you. Your Honor, Ms. Green, in your capacity as community manager, do you experience residents parking on lawns or their guests parking on lawns often?
We do. It's something we work on weekly as violations go out. Yes.
And do you know if have you witnessed vehicles parked on Mr. White's lawn on more than one occasion? Oh, you're muted, Dana.
Sorry. Other than the one that you showed on violation, no.
And do vehicles parking on lawns, is it known to cause damage to property?
Yes, it damages the property fully, so we do write them a violation to move it, or it will be towed within 24 hours.
Thank you. At any time during your
Well, that didn't help, but it shows that the witness is telling the truth all the way through.
employment as management, whether temporary or as the permanent manager for the community, were you notified of any concerns that Mr. White had regarding the dirt or grass area on either side of the driveway?
No, I was not.
With respect to the reason for maintenance's visit on March 18th, how did your team know to go there?
It was actually set up with you and Mr. White, a date and time that worked best for him. And then it was relayed to us to meet him or his care staff there at that date and time.
Thank you. Are you charging Mr. White to repair the driveway?
No, we are not.
Let me clarify that. Are you charging Mr. White to replace the driveway? Because you're not repairing it, you're going to replace the driveway, correct?
Correct. We are going to replace it, and no, we are not charging Mr. White for the replacement.
Thank you. And when you came on as temporary manager, were you replacing Brittany Parker as manager?
No, I was not.
Who were you replacing as manager?
Her name was Katrina. Do you want me to state her last name?
That I don't think that's necessary, but Katrina
No.
is not Brittany, correct?
Correct.
And do you know how long Katrina was manager at the property prior to your arrival?
I believe about 1.5 years. I'm not sure exactly on her time frame here as manager, but I believe around 1.5 years. Could have been a little longer or a little less. I'm not sure.
And let's just say we take a year into account. We'll just round it off there. And frankly, I don't know either, Your Honor. I'm just guesstimating here. But Ms. Green, if you came on in July and you are guesstimating that Katrina was there for approximately a year or possibly longer, that would calculate back to mid-year-ish of 2024, correct?
Correct.
Which is before Mr. White's stated time frame for when the driveway was originally poured, which I believe he testified was in November of 24.
Correct.
No further questions, Your Honor.
Do you have questions, Mr. White?
Yes, Your Honor. Ms. Green, are you there in the office nonstop from the time you arrive in the morning to the time you go home at night?
Yes, unless I have to step out to mail a package or go to the bank. I'm normally here from the time I get here to the time I leave every day. Yes.
So if I told you I've been up there a couple times and you were not there, how would you account for that?
Like I stated, if I'm not in the office, then I'm either off of work or I'm going to the bank or the post office for work. But normally my work day consists of being here the entire time that I'm working.
Okay, and during them times that you step out to do other things, is the office locked up or is there somebody there usually to handle things in your absence?
The office coordinators would be here to handle things in my absence.
Yes, and sadly, 90% of the time, not necessarily you. You are better than the staff that you replaced. But 90% of the time I came up there in the last year and a half, the office manager was never in. I would rely on their employees.
Mr. White. Mr. White, you can't
Yes.
testify right now.
Um, all right. If one of your staff that was there in your absence was to forget to tell you that somebody like me came up with this issue, how would you find out about it at a later date?
If I'm understanding the question correctly, you're asking if a staff member of mine forgets to relay a message to me, how do I find out? Is that
Yes.
correct? I would have to be told again, or the person or message would have to be relayed to me or staff so that I would hear it.
Would that require another phone call or another visit in person to do so?
You can raise concerns or put in work orders by coming into the office or making a phone call.
Okay. And prior to the pictures that were taken, is it your testimony that nobody in your office came by and looked at my driveway prior to your maintenance?
Correct.
Okay. Are you aware of the city, state, and federal housing guidelines?
I know.
Your Honor, I'm going to object on which city, state, federal guidelines
As
is
it
Mr. White
pertains,
referring to?
as it pertains to concrete trip hazards.
He's asking which federal. You're asking which federal state? I'm sorry, Ms. Dornbush, what's your?
Apologies, Your Honor. I was objecting because he just said, are you aware of state, federal, local, state, and federal guidelines? But I mean, there are numerous, and I was asking him to clarify with specificity which ones, and he did. He said regarding trip hazards.
All right, thank you.
Without looking them up specifically pertaining to something, as far as concrete, no. But you did share with us earlier today.
Okay. And that's all I have at this time, Your Honor.
Thank you. Ms. Green, I have some questions. How do you all document when someone comes in to file a complaint?
If it's a complaint or a work order would be put into our system called NetSuite. As well as if there's a complaint, they can go to the communication tab in NetSuite and write it down. Or if I'm present, they would pull me aside and have me come, handle it if I'm able to at that time. Otherwise, they would leave a note or email to me.
So they could put it in next week, or they can leave a note or an email for you.
Correct.
How, if someone left a note or an email, how is that memorialized? Is it transferred, or do you keep the notes? How does that work?
If it's a note, I would, definitely put it in the residence folder on the communication side so we'd have relevant, documentation of it. And if it's an email, I could print it as well.
Is there a hard copy folder for Mr. White?
I'm sorry, what's that, Your Honor?
Yeah.
There's a hard copy folder that they have for you.
We do have hard copy folders for residents, yes.
Have you reviewed that folder?
I have.
And are there any complaints that Mr. White has made in that folder?
No, there's not.
So he hasn't made a single complaint since he's been there?
I wouldn't know if he has or hasn't made one since he's been here, but as far as there being a record of it in his file, in his hard file, no.
And are there any communications in the, what did you call it? Suite note? What did you call that?
It's our operating system. It's called NetSuite. Sorry.
Suite. Are there any complaints in that next week system?
No, there is not.
Any questions based on my questions? Ms. Dornbush is your witness.
No, Your Honor, actually, I had similar questions and you covered them, so thank you.
Mr. White, any questions from you?
Yes, Your Honor. When you said you changed from one system to the current one, is there any possibility that it's something could have been omitted? Changing systems?
Your Honor, am I supposed to answer that or?
Yes, he's talking to you, Ms. Green.
When the conversion from Yardi went to NetSuite, all data was transferred over.
That's all I have, Your Honor.
And Your Honor, just one quick redirect just on that point. Ms. Green, just to confirm your testimony earlier today was that the conversion happened in 2020, correct?
Correct.
Thank you. Nothing further, Your Honor.
All right, thank you. I'm thinking, give me one moment.
I'm on the Zoom court meeting right now, so.
So, you acknowledge, Ms. White, that, Ms. Green, that your system relies on individuals to input the data into either an email or note or into the next week's system in order for it to be documented, right?
Correct. With the NetSuite system as well, if the resident utilizes the resident portal, they can also put in their own work orders.
All right. That's all the questions I have.
Your Honor, may I do one redirect question on that point specifically?
You may.
Ms. Green, in your experience as the manager at Lakeview and given the office coordinators that have been there during your tenure, do you have reason to believe that there is a lack of consistency by your team to note complaints and maintenance requests taken verbally into Yardi?
No, we would put them into NetSuite, but
I'm so
yes.
sorry, not,
It's-
thank you for clarifying, but the question stands.
Yes, we would put them into NetSuite, and no, since being the manager here, we've gotten on a consistent basis, and policies and regulations are held to a standard that they know to put them in immediately.
And you have not, have you seen there being a concerning amount of inconsistency, or would you say the staff has been consistent in your tenure there?
With me, under me, consistent, yes.
Thank you. That's all from me, Your Honor.
Anything else, Mr. White?
Yes, Your Honor.
Oh, no. No.
Does anybody in your office ever make a mistake?
Oh, God, this again.
Ms. Green?
And people can make mistakes. Yes, they're human.
So it is possible that somebody did forget to bring this up after I came in person to look at it. Is that possible?
Based off the timelines given of when you've come into the office, I was not the manager here during that time. So under me, these office staff have not forgotten.
Okay. That's all I have, Your Honor.
We're getting there.
Nothing further from me, Your Honor.
The trial is now concluded and it's time for closing arguments. I've listened to all the testimony, so please keep it brief.
I will absolutely, Your Honor. I would just indicate that based off the testimony and the evidence that have been provided, the bulk of Mr. White's defense is strictly based on his own testimony. There's been no physical evidence from him provided supporting his claim that this issue was raised and reported to management prior to the commencement of this case. It's been acknowledged by the parties that once management was aware of it, they went out there and they started looking at it, and they are now on track to get the driveway replaced. Testimony from my client, from plaintiff, shows, and the photographic evidence shows that the driveway is deteriorating, but there's no testimony or photographic evidence provided to show that the driveway itself has any severe deficiencies. And did you have an objection, Mr. White, or something to say?
No, my back just spasmed. I'm sorry.
It's quite all right. Your Honor, in that regard, the documentation provided does show there's a balance due and owing to the plaintiff, and there's been nothing presented by Mr. White that would warrant any sort of reduction in the balance owed. Based on all that, Your Honor, we would request entry of a judgment of possession requiring Mr. White to pay the full $2,995.30, which does include $175 in statutory court costs, and with the requirement that that balance be paid within that statutory 10-day time frame, which would require payment on or before April 20th.
Oh my God! All this over $2,000.
Thank you. Mr. White,
Yes, Your Honor.
your closing statement, please.
Their pictures, their own evidence shows that the dirt was never filled in at the edge of the concrete, which creates a 3 5/8 inch trip hazard, which is a safety issue and a violation of city, state, and federal housing guidelines. I also provided witnesses that come here to take care of me on a daily basis that stated that they don't feel safe and they have stumbled on that trip edge. Then also with the surface deterioration in the crumbled gravel, it's a huge safety issue for me being handicapped that I could slip and fall at any given point of trying to navigate that driveway. They failed to fix it. I proved with witnesses that this issue has been going on for 15 months and counting. And they didn't submit one contractor's repair estimate in the entire 15 months before your court. So, as a result of that, I feel that I should not have to pay any rent, or at best case, partial rent. And I'm not trying to sit there and, get 15 months worth of free rent. But I think obviously they should have to pay punitive damages. And I feel that I should not have to pay, that amount at all. And if I
He's going to drop a request for unpled punitive damages at the end of the trial after producing no evidence aside from his testimony. Okay.
do, may be partial. Keep in mind, I got cashier check for the whole amount and a written check for the balance. It's never been about the money. It's about them not getting it fixed, not having a contractor out here in 15 months to take a look at it. And, I'd rather go to the dentist and have teeth pulled than have to go through this again. So I'm asking you to deem that me withholding the rent was justified, and whatever money settlement that you want to do, I trust and have confidence in you that you would make the right decision. That is all.
Thank you.
And very briefly, Your Honor, just to close, just a couple of statements. The photos don't show, Your Honor, that the dirt was never filled in. The photos show the condition of the dirt on either side of the driveway as of March 18th. Mr. White has not proved that this has been an ongoing issue for 15 months. He's not presented any supporting evidence to that, and I don't believe his witnesses have testified that it's been an issue for 15 months. They've testified that it's been a long-standing issue. That is all. Respectfully, Your Honor, I don't believe that Mr. White's entitled to any rent abatement, but there is no counterclaim here for punitive damages, Your Honor, so he's not entitled to those either. And that is all.
All right, the court acknowledges there's no counterclaim for punitive damages, so that's not, and punitive damages are extremely difficult to prove in the first place. So that's not something the court is considering at all. I am concerned about the fact that very concerned, and I voiced that concern when we were here in court back on March the 25th was the first time that you saw me, on March 25th. But he voiced this complaint, at least in court, as early as February 11th. The problem the court has with this case is Mr. White, he seems very knowledgeable about concrete, indicating that he came into the office and he made complaints.
Oh,
The
good
office
Lord.
has been having various people serve as managers for a while now. My concern is his memory says that he's been in there every month, but obviously Ms. Green, who's been there for at least the past almost 8 months, 9 months, has not seen them, and I find it hard to believe that every month that he came in to complain from, let's say, July to November, even giving him the benefit of the doubt that he hasn't been able to go in since the accident from July to November, would forget to make any notation in the files regarding that. However, he seems very credible about his concerns regarding the sidewalk. And one of my concerns, Mr. Dornbush, is that he's correct. There's testimony here today that it's been looked at, but I don't have any proof that it's getting fixed.
You also don't have any proof that it was defective. None. So when are we relying on evidence, Judge?
I know that Ms. Green testified that she spoke to someone this morning, but they can't even give her a date when that's happening. So I have that outstanding concern. I need an answer to that question.
Your Honor, I mean, I can provide the court with proof that a quote was received. That came in after the April 6th deadline, which is why I did not introduce it into evidence today. But that can be provided to the court. I mean, Your Honor, the concern that I have, and the court says that they find Mr. White's testimony very credible, but they should likewise find my client's testimony credible. They've testified under oath that they're going to fix it, that they are going to replace the driveway. They just got the quote for my own notification to the court, Your Honor. I know this wasn't testified to, but I believe it just came in yesterday or the day before. And so that is newly received. And as my client testified to, they reached out to the contractor this morning to try to ascertain a date that it could be done, so that way it could be provided to the court during testimony today. If the court wants follow-up verification that it's scheduled, once my client has it, I'm happy to provide that to the court. I have no reason to believe, Your Honor, that my client would ever dare to step foot into this court and provide testimony under oath that they're going to replace the driveway and then not follow through and do it. My client would never do that. But I am happy to provide that proof to the court that it is being done. I know that there may be some concerns about weather and temperature, but things are on an upswing. Weather is getting warmer. And so I have every reason to believe that that's something that can take place fairly quickly. But I know we're working with constraints on a contractor. And so I can't speak to when that contractor is going to do it, but I will, as soon as we have the date, notify the court of that.
Your Honor, did they sign the contract for that contractor to do the work?
I
As
don't
I
know.
was saying before, my concern still remains the same, which is when that's going to happen. And I heard you say everything you said, Ms. Dornbush. It is still my concern about when that is going to happen. Your view of the way the sidewalk looks does not comport with my view of the way the sidewalk looks. I think for someone who's on crutches, it's a very serious concern, especially the side of the sidewalk. I saw the pictures of a person who parked in a spot on one occasion. And somehow, according to Ms. Green, that's the only time she knows about that happening. And he also testified that it's that there are blocks on the side, and so it's not really on the grass usually, but the witness who was here today testified it was her car, and it was on the grass that particular day. So someone is paying attention.
I agree, Your Honor. My client is paying attention. They have testified that they are having it replaced. They themselves can't do it. They are waiting for the contractor to give them the date. Ms. Green, have you gotten a response back from the contractor since we've been in court?
I did. I was trying. I didn't know when I could interject, but she did get back with me at 12:43, and she said that I am just waiting on the permits to be approved, and we'll get you on the books. So she's already requested for permits to be able to pour.
Did you sign the contract?
Approval was given by myself and higher management. That's why they've already moved forward with trying to pull the permits to get it on the books.
Did you sign the contract?
She's not on the witness stand team anymore. All right. So the bottom line is I have several issues with this. One, Mr. White, is that your testimony is that you've gone in, but you haven't taken any of the steps through the portal or through any other mechanism to document that you've gone in. And the witness testimony here today about the fact that you told them that you've been complaining is hearsay. I can't even take that into consideration. So it's just your word versus their word. My concern is that, you have severe memory problems, first of all. But secondly, there's this issue of the fact that Ms. Green can't testify to what he told people before him. But she also can't be held accountable for things that you told people before her when she's never been told herself. And there's no documented evidence that she's been told. Those are the concerns that I have, and I'm still grappling with that. The other problem, sir, is if you're going to withhold rent for issues, complaints, things that haven't been fixed, you have to have the documentation show that you've complied with the laws. The law requires, one, that if you withhold rent, you have to put it into an escrow account. I don't show that you put it into an escrow account. I do know that you showed the magistrate when you were here on February 11th, who held the $2,000 money order up to the camera and showed her, and she wrote a notation about that.
That's made out to Sun Homes a cashier's check. My banks don't do escrow accounts anymore.
But the problem is,
that doesn't relieve you of your responsibilities under the law.
You withheld rent. You have no documentation that you told them that you were withholding the rent because of the concrete. Is there a letter or a document of any sort? You haven't presented that to me, that you were withholding rent for that issue.
Your Honor. Like I said, I dealt with numerous people in there, and they just keep passing the buck down below. And before I even did this, I even warned them that the next month I'm going to withhold the rent until you guys fix this. But I have a cashier's check instead of an escrow account because my bank don't do escrow accounts. But it covers everything. Payment in full. All I wanted was for my driveway to be safe for all the medical staff coming in and out of here, which it hasn't been. And it's a huge concern to me.
So this is what I'm going to do, because I do have concerns about his driveway. And I'm not telling you that I don't find credible that she's going to be repairing the driveway. What I'm telling you is I want it documented. I want to see proof that it's happening. And what I'm also saying is that I believe that he told somebody at some point. Now, whether he's gone into that office every single month, I don't accept that part is true. I do believe that he's been talking about this issue for a long time. With respect to any argument as to the fact that he signed a lease and the lease got lost in the office and therefore he didn't sign another lease and he shouldn't have to pay the late fees and all of that. Mr. White, you have a duty to mitigate your damages and you should have actually just signed a new lease so that you could stop these additional fees from accruing every particular month. So you should be mindful of that in the future.
Yes, ma'am.
As far as the driveway situation is concerned and whether or not he's entitled to any abatement, I believe that the rest, so he only pays, is that site rent only and the actual lot the actual mobile home belongs to the county, correct?
He owns the mobile home, Your Honor. He pays lot rent and then water sewer usage.
All right, I think what I need to do is look at the ledger, to make my decision about what I want to do in terms of if there is any abatement. What I do want to see happen is I'm gonna have everybody return one more time for my ruling on.
Oh my God, I was trolling you guys. I thought there was a ruling. There really isn't. This is a 2-inch pot here. Pay what they're requesting or get out. That's it. This isn't close. As a matter of law, this isn't remotely close.
This, and hopefully by that time we have the driveway fixed, or at least a date for when it will be fixed. And I can do it on the standard instead. Just a couple weeks. Just, well, I'm not back. Am I back on the 29th?
You are back on the 29th. You had told, but hold on, keep in mind that everything's on from the 22nd. The magistrate will be over to the 29th as well. So the 26th might be the date here.
This is the first one in May. That's the first one in May.
Oh, the first one was May. That would be May 6th there.
I'll put it on for May 6th.
May 6th.
Correct. And I'm gonna do this at 3:30 p.m. That's a standard Wednesday afternoon. I'll issue my opinion at that time.
Understood.
I don't even know if there'll be a hearing to issue an opinion. They could just have a clerk hand out an order. Like, I don't even know if we'll get the ruling.
Your Honor, with respect to, I know Mr. White had indicated that he had his payment for April. Do you want him to make that payment or hold it? And then same question with respect to May.
He should make his payments for April and May.
Okay, and is the amount in April going to be over $800? Because that's why I wrote the check for.
Your Honor, I can add up these charges for Mr. White if it pleases the court. Rent is $750. The month-to-month fee is $41. Water was $20.63. Sewer was $10.09. And then there's the $55 late fee. And I don't know what I did, but I just messed that up. Hold on. 1009 plus 2653 plus 750 plus 41 plus 55. It's 876.72.
Oh my God.
76.72. April. They'll have the check today.
Thank you. I'll see you all on May the 6th at 3:30.
Thank you, Your Honor.
Your Honor. Bye-bye.
Brecken, what are you doing to me? Ah. Law Talk with Mike, the worst channel on YouTube. Thank you for coming out.